Any mention? Supplementary item number 1.
Made, please, Your Lordship.
Lordship, please. Lordship, please. This is that same issue, Lordships, where we had come on the first round, where they reduced the profit margin of the retailers, and it was the organization that filed the writ petition, my lord. The order was passed by Your Lordship saying that this is violative of Article 14. Subsequently, that order was taken to the Supreme Court. It was argued, then withdrawn. Now, subsequent to that, my lord, they have issued another notification with the entire intent that the judgment can be somehow bypassed, whereas the profit now has been made 15.5% in regards to the retailers, and on the same date, another notification, Your Lordships had made an observation that the other stakeholders has not been touched in regards to the profit margin. They have now reduced 5% of the central bond, making it 5.5%. So the entire exercise.
How much?
It was 6%. On the same notification that was 12/9/2025, challenged on the last occasion, my lord. And Your Lordships had already observed. I'll first take Your Lordship to that observation that was made in that order. That order, my lord, is at page 250, annexure 20.
Yes.
The first point that was raised is 253, my lord, para number 3. That is the issue that was raised. I'll just read the issue, my lord, first. The issue that arises for consideration, therefore, is firstly whether the amendment reducing the retailer's profit margin constitutes a valid exercise of its regulatory power, and whether it crosses the line into the realm of a manifest arbitration and unreasonableness. Secondly, the most crucial issue is whether the substantive link exists between the implementation of a new tracking system and the decision to reduce the retailer's margin. As is much there is such a link, the same could be considered to be a disguised or an indirect method of funding a third-party contract which transgresses the limit of legitimate relations. Thirdly, the issue is whether the directive of the retailers to sell at the new maximum retail price is reasonable or rational, considering the fact that the necessary hardware or software is yet to be in place to make the system functionally operational at a retailer's point of view. So that is in regards to the scheme that was introduced by the government, which is called an IMES scheme, which is a track and trace system, which obviously when the last day we have categorically said that we have no problems with this scheme. In terms of this, my lord, Your Lordship's observation page 275.
Yes.
That para number 25, my lord.
Yes.
The petitioner, in the pleadings, though not categorically statements have been made, however, have sufficiently indicated the nexus between the increase in cost and the reduction of the maximum profit margin from 15 to 20%, which this court has taken due note of. The state, though vested with the rule-making power under Section 36 of the Meghalaya Excise Act to make the rule relating the excise revenue, even without any criteria or standard being laid down. This, however, cannot be said to be the mean that the state government formulates the policy or acts in exercise of a delegation of power, which would offend Article 14 of the Constitution. Though normally the delegated legislations cannot be challenged on the ground of unreasonableness, however, if the same is anchored to the Article 14, in considered view of this court, such delegated legislations can be challenged on the ground of unreasonableness and arbitrariness. In the instant case, and observed earlier, the introduction of the IMS scheme coupled with the reduction of the retailer's profit margin from 20 to 15% by way of the impugned amendment dated 12/9/2025 without any discriminable impact or reduction in the profit margin on the other stakeholders would surely therefore amount into an action which is unreasonable, arbitrary, and against the principles of equality and fairness. And as such, the amendment to 372 as contained in clause 5 of the notification dated 12/9/2025 is liable to be struck down as violative of Article 14 of the Constitution. This judgment, my lord, was subsequently challenged in the Supreme Court at page 221, 279 by the state government.
Yes.
After hearing the arguments, so-and-so seeks permission to withdraw the SLP, and the permissions is sought for is granted, special petition is dismissed as withdrawn.
Yes.
Subsequent to this, my lord, now with a notification, two parts, my lord. The first part is at page 282, annexure 23, is the present notification which they have introduced.
Impugned notification.
Yes, the impugned notification, my lord. There are 13th of May 2026, my lord. The amendment is to 372 again. In the principal rules, in Rule 372, Sub-Rule 1, for the clause B of the following shall be substituted, namely, B, the kinds of liquor and maximum percentage of profit margin be revised on the retail sales as shown below. So the beer including so-and-so is 15 from 5%. So all have now been just increased to 0.5% from 15% that was initially introduced in 2019. And if your lordships, just to remind your lordships that in 2017, when the first notification came up with an amendment, the percentage was fixed at 20%. From 2017 to 2025, my lord, that notification remained in place, and 20% is what the profit was generally being given to all. It is only in 2025 that notification came and reduced it. Now, in terms of this, my lord, if your lordships will come to page 284,
Yes.
this is the another amendment that has happened. That is on the same date, my lord. That is number 2, amendment to Rule 44. And the principal rules of rule for sub-rule so-and-so, the following shall be substituted, namely, the maximum profit margin of the central bond warehouse on the sale to the bonded warehouse shall be 5.5% on the IMFL, beer, and subject to the minimum profit margin of 65 rupees per case, and the bonded warehouse on their sale of IMLF off and on license shall be maximum profit of 8%. Now, this remains the same because it is the bonded house, the state bonded so-and-so, while we are subject to the maximum profit rupees so-and-so. So the entire exercise that was done in regards to the previous round, my lord, where we said that this is something which cannot be done, your lordships has already observed that it is violative of Article 14. They go ahead and amend this by bringing 5% on my side and reducing the 5% in regards to the central bond. Now that was done, my lord, in regards to certain views that have arisen in terms of this. Now, my lord, will come to my writ petition, my lord. I'm just sorry, my lord, just once. Page 35, my lord, page 46, paragraph 46, my lord. There was another judgment, my lord, that was referred in this international spirits, my lord, where that commission for the central bond house was introduced. And that is the observation that your lordships has also maintained in that order. May I just read paragraph number 46, my lord?
Yes.
That this honorable court in International Spirits and Wine Association, this honorable court sustained the amendment to the Meghalaya bonded warehouse, which the central bond warehouse was created. And the court observed the only legitimate grievance which the writ petitioners have against the impugned rules is that to maintain the fixed price of a commission received by way of the bonded warehouse has to be shared with the central bond house, resulting in a diminution of the margin of the profit of the earnings. And in second, it says, that is the observation made, it is required that the extra amount of commission is to be first absorbed by the government by reducing its taxes on a bottle of liquor, and thereafter considering enhancing the price of the bottle, if required, reasonably, so that the enhancement in price is minimal and does not affect the commission earned by the bonded house or the market demand. So this was based on this that the 12/9 notification was issued, my lord. May I just take your lordship to that notification? My lord, page 291. It starts, there are 3 notifications of the same date, my lord. And at 294 annexure 28, is the amendment to 372, and 295 is where that amendment of Rule 44 happened on the last occasion. Number 3, amendment Rule 44. Page 295. So this is the first notification by which this 6% was introduced, and subsequently, my lord, at page 296 is the 372 amendment by which the 15% was fixed. So now the entire exercise is to bypass that order passed by your lordships to only introduce a 5% with your lordship's observation that the other stakeholders have not been touched. So they decide to reduce 5% there and increase 5% here. Whether that is permissible, my lord, your lordships have already said that that this is not permissible. The right of the legislature remains. There's no dispute to that. But whether the power has been has been exhibited in a manner that it bypasses the order which has been passed. That is the difficulty. 5% here and 5% there may not make a difference, because the maximum retail price which was introduced, my lord, which is the first.
0.5%.
Yes. May I just read that, because that is an important annexure, my lord, that is at page 60. We relied on the last occasion also on the same price which was fixed. That is at page 60, annexure 4. That was the first amendment to 372, by which the definition of maximum retail price was introduced, my lord. It's at page 60, annexure 4.
Yes.
The fixation of the maximum retail price 1A1, the maximum retail price for each kind of liquor, beer, wine is fixed by the Commissioner Excise every year. The MIP is derived by adding ex-bond price, ad valorem, pass fee, VAT, and the maximum percentage of profit allowed for each brand. So that was the amendment that was introduced, by which a maximum retail price was introduced. And based on this, my lord, in 2019, the 20% notification came into picture, which has also been annexed, my lord, here.
Okay, this you understand. Yes, Mr. RK General, accepting.
Yes, my lord. My lord, the learned council, my lord, learned senior council has argued two things, my lord, before your lordship. One, that the order passed by, or the notification issued by the government is an attempt to bypass the order of this honorable court.
There's a word for that. What's it called when legislation is used to circumvent court orders? There's a word.
Yes.
What's that word called? It doesn't come to mind right now.
Yes, my lord. Prithvi Chand, there are a number of judgments, my lord. But
No,
that
there's
is
a certain phrase that's used when the executive to overcome a judgment of the court.
the basis of the lordship.
Nothing to do with anyway.
The circumvent, one was that used is to circumvent that order.
Yes.
Yes.
No,
Yes,
yes,
I
please carry
can
on. Sorry.
clear that.
Yes.
Yes, madam. Now, so there are two arguments which have been advanced by London Senior Counsel. One, that this notification circumvents the order of this honorable court. That is the first argument which has been. Lordship, kindly see, my friend has read your lordship's order.
Yes.
Is paragraph 25, my lord. Kindly have that paragraph. Page 25, my lord. Paragraph, page 275, paragraph 25, my lord.
Yes.
The petitioner in their pleading, my lord, your lordship has paragraph 25. Petitioner in their pleading, though no categorical statement has been made, however, have sufficiently indicated the nexus between the increase in cost and reduction in maximum profit margin to 15% from 20%, which this court has taken due note of. The state, though vested with the rule-making power under 36 to make rules excise revenue even without any criteria or standard laid down, however, cannot be said that the state government formulate a policy to act in this so and so. So what your lordship has said, according to me, my lord, is that if the state is not following any criteria or standard, then it is violative of Article 14. That is what your lordship has held in this paragraph. Though the only problem which we faced, my lord, that there was no pleading in the previous writ petition, my lord. Now, my lord, I have prepared a compilation of all notifications issued time to time. I'll request my friend to place that notification, my lord. What is the history, how much margin they are getting earlier, now, and with the amendment. Everything have, my lord, kindly see. Your lordship has the notification, my lord, the compilation, page 1 of the compilation, my lord. This is a 2015 notification, my lord, of the amending the rules, my lord, statutory rules, and your lordship will find 2015 it was 10%.
Yes.
Yes, 10%, my lord. It was revised in 2017 to 20%, my lord. On next page 3, my lord. Page 3, my lord, your lordship has page 3, it was 20%. Now, at page 5, my lord, which my learned friend has referred to, my lord, your lordship will have the notification at page 5. This is a notification relating to central bonded warehouse, my lord, page 5. And in this central bonded warehouse, my lord, there was no commission fixed payable to the central bonded warehouse in 2020. No maximum, no minimum, my lord. The lordship will keep in mind one more fact, that it is a maximum. It's not that they have a right of 15%. It is a maximum. It can't go beyond 15%.
It is a ceiling. Yes, we understand that. Yes.
Yes, so, my lord, is to say that I am entitled to 15.5% in law or 15% is not correct, my lord. Kindly see now
It's not a question of entitlement. It's a question of the manner of the reduction. That's the only thing.
Manner, I'm demonstrating the manner only, my lord. That is for that purpose only I am placing it, my lord. Manner is also.
Mr. Carpenter, we do one thing.
Yes.
You have a prayer for interim protection.
Yes, because
Then
I'm saying
you just put in a small objection in process compilation.
I'm saying it's an absolute cosmetic thing only to bypass the judgment. That's it. My allegation is this. And all these points have all been argued previously. Your Lordship has already applied your mind and given a judgment to that effect.
May I, Your Lordship, kindly help me one more, at least 2 minutes to counter the submission of my friend.
No, Mr. We will give you ample opportunity.
Yes, my lord. Only one page, my lord, so that Your Lordship picture will be clear. Only please come to page 28, my lord. Page 28. I will not.
The writ petition.
Of this, the compilation, my lord. Compilation. Okay. Page 28. Page 28, my lord. I will just demonstrate how no prejudice, nothing has been caused to them. Page 28, my lord. Now, Your Lordship will see this is a brand called Vintage Cast Mature brand, my lord. Your Lordship has the brand, my lord. The size is 750. Right, X bond price, my lord. Fee is a X bond price is 1179, my lord. The price is fixed, my lord. 1179. Transport fee of 100 rupees is levied on that. Literacy fee of 10 rupees is levied. Tax component is 708 rupees is levied, my lord. The VAT component is 599. Price becomes 2,596, my lord. Now 15.5% margin on this, my lord, is 402 rupees of the retailer, my lord. It becomes 2998, my lord. So price becomes 29 and retailer's lifting is.
This is a price per bottle.
Yes, my lord. This is how now, my lord. So kindly see what has happened, my lord. This 1179 includes the profit margin of central bonded warehouse, and manufacturing cost. On profit margin of bonded warehouse, central bonded warehouse, and on tax component, they get 15.5% on tax, and so it becomes 3,000 rupees, my lord. From the and they are saying that no, and if you kindly see their prayer also, just see the prayer in that light, and the volume they kindly see the prayer in this light, my lord. Prayer. What is the prayer, my lord?
Yes.
Prayer at page 47, my lord.
Yes.
Kindly see the prayer. What is the prayer, my lord? Prayer at page 47. Page 47.
Now, why didn't she succeed in the Supreme Court? Again, the judge, the court,
this was the, my lord. What has happened, my lord, that your lordship has observed that there is no fact pleading, etc., my lord. So
no, I mean before the Supreme Court, you made the same argument.
No, my lord, because in Supreme Court the issue was your lordship's order was based on the premise that it is factually it is not clear, it is a policy, and what this prayer in 47 is my answer to my Supreme Court order, my lord. Kindly see prayer in 47. Okay. What is the prayer? Yes. Kindly see. I did argue this. A writ in the nature of certiorari ought not to be issued, set aside the notification dated. A writ in the mandamus to issue directing respondent to refix the margin, my lord. So ultimately, your lordship knows that what they are asking for refixation of margin. They are not, and 10%, 15%, and I have got the notification from all other states. The margin is not more than 10%. They are getting margin on the bonded. They are getting this 20% margin on bonded, central bonded, because all these materials were not there in the previous writ petition. These materials, and that is why I wish, and there is no miscellaneous application seeking any stay.
Not required. It's not required. May I say this, my lord? When this matter was argued, I must say this off the record. The Honorable Supreme Court Justice P.S. Narasimha, against whom this matter was argued, made a categorical statement saying that this is a very well-written judgment by Justice so-and-so, and this court will not interfere in it. This is a statement that was made. After arguing everything, it was withdrawn. So everything, and 10%, my lord, he's talking about a volume. If state of Meghalaya has a volume like West Bengal, if it has a volume like Chennai, I can understand.
You file your objections, yes.
Finish my argument.
Yes.
So therefore, I will file reply, place all the materials before this honorable court, and I will show that this exercise is
after 1 week
out in bona fide.
Are you free after 1 week?
my lord,
You will have some
difficulty,
personal
my lord. That is
difficulty.
the problem. Your lordship have first week July, your lordship may
First
have,
week July,
because this is
okay.
all first week of July. We'll file reply, my lord, and your lordship may hear the matter finally in first
If
week
my
of July.
learned friend, if my learned friend doesn't have a problem, first week of July, I'm not available. If it is not any inconvenience after 10th or 11th, because the courts are shut, I won't be available. Lordships, in the meantime, we'll finish the pleadings. All I'm saying, if it could be listed for an interim protection sometime before the vacation, I'd be grateful. If he's available, I do not know. 20th, 19th, whichever date he wants, 2 weeks from now.
Because this is
Yes.
MRP, entire product is already out in the market. Everything is there, my lord. Your lordship may hear the matter
Another
finally
question,
in
whether the
month.
earlier judgment was implemented or not.
No.
It was not.
No. Let me say this categorically, and I'm ready to make a statement. No. It was always 15%, never 20%.
The lordship has said that you reduced the stakeholders. We carried out the exercise.
No.
We
The
found
one
that
other question
now,
is
my
this: whether when was the judgment passed?
26th of March.
Okay, 26th of March. Whether
26th March.
after the judgment was the
March.
was it implemented by the state?
No.
No, we went, no, my lord.
No,
We
no.
implemented only after.
My
the
statement
order
can be
of the
recorded.
Supreme
Then that's contemptuous. Yes.
Order
Anyway,
of the opposition.
with that-
And I have filed a contempt because of that, which is listed before your lordships. To say that they have gone ahead and done this without even implementing your lordship's order, after being dismissed from the Supreme Court. Listed today before your lordships.
I heard
They have a birth right
Mr.
of
R.B. Falcon, Leonard Senior Counsel, with the SM for the petitioner, issue notice. Leonard Advocate General with Ms. H. Kavanlang present on behalf of all the respondents. No further notice. Stop. The writ petitions directed against the amendment dated 13/5/2026.
13.5.
13/5/26 amendment was made.
This amendment subsequent, yes, my lord. That is what we've impugned. That's a page, my lord.
Which is contained in lecture
Extra 25 at page 282, my lord.
Yes, my lord.
25 and
282.
and 282 of the writ petition. Stop. The Learned Senior Counsel submits that after the order of this court passed in WPC so and so, the state respondents, in order to circumvent the said order, have amended the rules by increasing the profit margin by 0.5% and decreasing it with regard to central bonded warehouses by 0.5%. It is submitted that this action is a colorable exercise of power. He prays that the MP notification to be stayed, yes, until further orders. Next parameter, Leonard Advocate General, appearing for the respondents, submitted that the action of the respondents were within the scope of their powers, and in this regard, prays that the matter be taken up for consideration of interim prayer when.
I'm
So
requesting.
final hearing, my lord. I'll reply, my lord.
We'll finish up pleadings in the meantime.
Yes, sir.
If it is not inconvenience, around 14th, I have a matter fixed.
July.
15th, yeah, 15th or 14th, my lord, whatever is convenient to your lordships.
15th, my lord.
15th.
May hear the matter finally, my lord, 15th.
15th.
Yes, sir. Come on.
Because I'm not, there is no interim prayer, my lord. There is no
11,
interim prayer.
11,
So there-
14.
Yes, absolutely, 14th is fine.
Your lordship, there is no interim prayer. There is no interim prayer, your lordship. So therefore, your lordship may hear the matter finally.
Yes.
There is an intent prayer which I've made.
But in where is the prayer portion? There is no prayer portion. In the prayer, there is no prayer.
Huh?
In one paragraph, you say something that there should be some interim
Yes,
prayer,
yes,
but
yes,
there
yes.
is no prayer.
Please. Yes. Yes.
Go to the question last. 18 interim.
He prays that matter be heard. Stop. Accordingly, let the affidavits be put in by the state respondents.
By 2 weeks, my lord. In 2 weeks.
And in 2 weeks, so they join the 2 weeks thereafter, and the
Yes.
matter be posted for final arguments on 14th of July,
Great.
2026. Yeah.
Grateful, my lord.
Extremely grateful, man.
2. Item number 2.
Yes. Similar, item number 2 is also similar. The another association has filed the same grounds. Extremely grateful.
Same order, my lord. Same order.
Daily list item number 1.
The customs appeal. The delay was condoned on the last day, madam.
Yes, sir,
It
yeah,
is for admission.
yes, sir.
It can be admitted, madam. Final argument.
We admitted.
Yes, in fact, but the next day we can dispose of the matter because there is no ground, madam, for that. Even for the appeal
You
also no
come
ground.
against the
Suspect order.
sister order whereby they
Appellate authority has released their money.
failed to establish his currency was smuggled
Yes.
gold. Oh, so
Because my money is just
Here,
unnecessarily
gold was
lying
not
there.
seized, my lord. Gold was not seized.
you seize cash.
Cash, my lord.
Then
Those were
how
the
do you link it to gold?
Those were the self from the statement of the arrested persons. They categorically admitted before the during the investigation, my lord, that they took gold from Shillong to Nalbari, my lord, Jagi Road. They sold it and these are
What is the amount?
69 lakh rupees.
69 lakhs. Yes, we'll hear it then.
We can hear that.
Yes, sir. Until the counsel for the parties, the matter stands admitted for consideration. Just for hearing after 2 weeks.
Item number 2. 2.
Well, this is with regard to seizure in Kanpur, my lord.
Not have anything remains now, Mr. Kriyam.
Nothing remains, my lord. They have appellate remedy now.
Draw it.
Lordship, we'll try to satisfy your Lordship with regard to jurisdiction, your Lordship. And moreover, we have made the payment under protest, your Lordship.
It's not about jurisdiction only now, my lord.
You've got the truck back.
Yes, Lordship, we have paid under protest, my lord. Lordship, that the GST from
the
UP,
protest-
Lordship,
Yes, what is your submission?
Lordship, that the respondent 4 and 5 appear, your Lordship.
What's 1.5?
4 and 5, sir. The GST of Uttar Pradesh, your Lordship.
GST?
Commercial.
Dr. Mosika is here for GST.
Superintendent Commissioner of GST, your Lordship.
These are state GST, my lord. But I have
State GST?
Yes, your Lordship.
Who's the state GST? Where's Mr. Sinkan?
No, they are
No,
from
UP state GST.
Oh,
Yes,
UP state GST, sorry.
Lordship.
Let's see the office note.
In fact, they have contacted me, my lord.
What did he say?
And they've given instruction that trucks have been released, my lord. They deposited the money. Now the remedy for them is to file an appropriate appeal before the appellate authority in UP. My lord.
Yes, with the senior.
Lordship, he is out of station, your Lordship.
Then we'll close it.
Lordship, after a week, your Lordship, we'll try to satisfy your Lordship.
Yes, Mr. S. Kiriam, with some accommodation due to the absence of the senior arguing counsel just after 2 weeks. Next day you'll argue it, right?
My senior is leading this matter, your Lordship.
We are a specialist in the chamber and adjournment.
I'll leave next, Lordship.
Your Lordship, I beg to mention item number 26. Your Lordship.
Contempt matter?
Yes, Your
Why are you
Lordship.
mentioning it?
Your Lordship, we have filed an SLP before the Apex Court and we're still waiting for the outcome of the case.
Okay, yes. On the other side, nobody? Yes, after 2 weeks, yes.
Much obliged, Your Lordship.
Yes.
Wait, please, Your Lordship. Lordship, I beg to make a mention of item number 35, Lordship. Lordship will be filing a rejoinder in the course of the day.
You have filed a rejoinder?
They have not filed a rejoinder yet.
Lordship,
Suppose
we'll
hearing
be
today,
filing
you're
in the
supposed to
course.
file meanwhile.
Lordship,
Okay, yes, after 1 week, Mr. Singh. Yes.
highly obliged, Lordship.
Hello, pleasure.
Yes.
May I please, Sir Lordship, I beg to mention item number 29, Lordship.
29.
Yes, Lordship.
Yes.
After 2 weeks,
Review
Lordship.
petition. Why?
Yes, Lordship.
Objection.
No objection, Your Lordship.
Yes.
Highly obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 33, Your Lordship. I'm praying for 2 weeks' time, Your Lordship.
This matter has been adjourned every time. Why?
Some personal difficulty, Your Lordship.
Who's the leading counsel?
H.L. Sankaresu.
No objection? No objection. Yes.
Supplementary list item number 1.
Filed, my lord.
Yeah.
And how contempt is maintainable, my lord? Your lordship has seen.
I've not seen.
Notification
Let us see.
Because notification has been issued, my lord, and notification is under, and that and division bench, they have challenged the notification, my lord. On merit, they have challenged it, and they are filing contempt that that notification is a case of contempt, my lord.
Yes,
They can't write in two, my lord. Either it is
I
a
think that
contempt or
you have not, this contempt is for violation of the early order.
Yes,
The things that non-implementation.
yes, and also the
Where's
fact.
that pleading you made?
Yes, and also the fact that they have tried to circumvent the order by introducing the new.
The correct word is colorable legislation.
Colorable legislature.
Right.
Yes, madam.
Yes.
my lord. My friend is here, that is why he has filed third petition also, 2 petitions and 1 contempt.
Where is that?
Yes, my lord. Just. So I don't know where I have made that statement. Just one. Where have we made that statement? Yeah, where they said that the order has not been implemented till now. I mean.
And your lordship has simply quashed the order. Your lordship has not said that there will be no notification, my lord.
No, not occurring no notification, but during the intervening period now, the order was quashed, right?
Yes.
So its consequential action on the part of the respondents is to implement or is to roll back whatever he had done, correct? So because the situation is restored, you can't make the submission, Mr. Abhijan, there is no time limit being given.
No, my lord, if it would not have
already
been
made
done
a
within
statement
March
already.
is your lordship order. We went in the Honorable Supreme
We take
Court,
notice,
after
let them
that
file
we-
an
Yes,
affidavit.
no, but my lord, just one small thing, my lord. In regards to the implementation of the scheme, your lordship has already observed that when the order was passed and subsequently till today, the implementation, my lord, has not happened, irrespectively whether I made a statement or not. The fact still remains is that they wanted to bypass that order, introduce this new notification only with an intent that today, if the legislature has the power, can they still do it and implement in this manner, just to provide this the power to the legislature that I can do something under 21 and 36. That still remains, that this is still to be circumvented, because they have done it in such a manner, my lord.
Yes.
The implementation.
We will.
Lordship, I am
issue
raising
notice.
two preliminary objections as to the filing of
We put it on
contempt.
objection.
One,
We'll hear it.
Yes.
Doesn't mean that we're only holding you in contempt.
The only issue is
Just the
whether
first
the
stage.
prima facie case is made out or not, my lord.
You will hear that. Yes.
Allow me to
Heard Mr. Abi Fukan.
only on prima facie.
And Senate Council issue notice. You accepting notice?
When is it?
Yes, I will
Yes,
do
sir.
that, my lord. I'll let
Then
my
Attorney
friend
General
supply a copy to me.
and with MSS
Along
Lalu
with-
at present, on behalf of number 2, no further is required. List on 14 July
14 itself, man.
for objections to the general praise that he be allowed to file a preliminary objection. The same be on record before the 14th, yes, with advance copy to the counsel for the petitioner. Yes.
My friend is here, at least he should have 3 cases and enjoy the weather also.
Now he's a senior counsel, so yes,
Senior counsel, we have to respect him. That is
Yes.
here.
you have to give him that deference, yes.
Yes, madam. Yes, madam.
Please, Your Lordship, I'm praying that this matter may be taken up at the end of the board, Lordship. Learned DSJ is currently
Any
on
interim order you're asking?
Because promotion order has been issued, Lordship, to the petitioners. Thereafter, it was cancelled on account of category review, Lordship. So I'm seeking some protection because they might.
Okay. This will notice after some time.
3,
I have similar prayer, Lordship, item 3 as well.
4,
This is another case of.
Hearing.
Yes, ma'am. What's disturbing here, my lords, is the notice. My lords, kindly turn to page number 15.
Have you not made state party?
My lords, I have.
Then where's the council?
Could you please block?
You didn't serve notice.
My lords, not yet.
Then you serve notice of state, yes. This tomorrow. Notice we serve to state respondents before. Not next step, you give a notice.
5,
You're a government panel lawyer, you know that, yes. Yes, Mr. Siddiqui.
As back as on 28/5/24, your lordship had passed a judgment that the petition be reviewed. The state government has filed an appeal and the appellate court had divided lordship order.
Mr. Siddiqui, something wrong with the. Can you just check your end? You just. Yes.
Yes, madam.
Yes.
So by judgment dated 28/5/24, my lord, your lordship had directed the petitioners, being aggrieved, they file an appeal before the revision bench, which upheld your lordship order on 26th. Then again they went to Supreme Court by SLP, and SLP Supreme Court did not interfere into the matter, while order dated 27/5/25. But till then, the petitioners are yet to be regularized, and when we approach them, they said the matter is pending before the cabinet for approval.
I will have to take instruction.
Yes, sir.
Exit notice, madam.
Yes, senior counsel. Accepted by so and so. Issue notice. MS Arconi.
All the respondents,
is
madam.
present. Acceptable. We have all the respondents. No further is required. Just after 2 weeks for instructions for affidavit. Yes.
Madam,
Yes.
5 and 6 is connected.
7,
So this is a freedom of bank account.
Yes, Mr. Day.
I've received my no objection to decrease account launch.
Where is Mr. Day?
He is appearing good.
Yes.
This matter,
Yes.
in this matter, my lord, I was directed to take instruction.
Yes.
That whether the disputed amount
can be defreezed or not, my lord. So
Yeah.
I have received a letter dated 10/6/2026, my lord. My colleague will just forward it to my lord. The letter.
Yes.
If I am permitted to read, my lord, this is to certify that the bank has no objection in permitting account holder, namely so and so, to withdraw and operate the amount lying in the said account, which is not under dispute and is free from any claim, restriction, lien, attachment, or legal implement.
Yes.
So the bank has clarified, my lord,
Right.
that
So
they have no objection.
Mr. SD, appearing for the respondent number 3 bank, has produced instructions, an instruction dated 10/6/2026, which whereby the bank has no objection in permitting the account holder, namely Sri Bharat Chetri, holder of account number so and so, in operating the undisputed amount available in the account.
We haven't received a copy of that letter. Anyway, Your Lordship, we are just a formal party.
Instructions, SOP is directed that the account of the petitioner, being number so and so, as far as the undisputed amount is concerned, shall be defrozen, and the petitioner allowed to operate this account. Then what to this matter?
The entire matter can be closed down, my lord.
Yeah, it's closed, disposed of. The petition
Yes,
can be disposed.
the parties submit that in view of the instruction received, the matter, in view of the order passed of the court, the matter may be closed. Accordingly, matter stands closed and disposed of.
Oblige, Your Lordship.
Daily list item number 1.
Please, my lords. Lords, I'm appearing for the petitioner in this matter.
Yes. We will give a name, or you suggesting a name of some, but the amount very small.
Very
so
small.
we'll have advocate arbitrator.
My lord, I have to. We'll talk with
You're
somebody.
supposed to take instructions today, independent lawyer. Then we'll suggest, the court suggests who's ready to become arbitrator.
My lord, I have already talked to Mr. Keshav. Yeah, Kishore Gautam. We can contact with him. No, other side also, my lord.
Yes, they have suggested which name?
Kishore Gautam.
Kishore Gautam.
Yes.
Yeah, he's fair enough, I think. You will accept. What's his name?
My lords, my apologies. There was some network issue. My lords, my most humble request is, as my lords directs, my lords, any independent person. Please.
Right. Yes. Today the matter is fixed for appointment of independent lawyer as arbitrator in instant matter. So, on the suggestions received, Mr.
Kishore, my lord. There are two cases, Gautam. One Kishore, one Kishore.
Yes, is proposed to be the arbitrator, and the matter stop registry to intimate him to obtain his consent in the matter just after 1 week. Once he obtains consent, then we'll appoint him. Yes.
Item number 2.
Lordship, in this matter, I have to, on last occasion, I have to seek instruction regarding this non-payment of maintenance allowances for the respondent.
No, yes, last time your colleague appeared, she wanted 1 week's time to obtain account statement from the office with regard to deduction made from the pay of the appellant.
Yes, Lordship, but however, the same could not be applied, Lordship. Because while Lordship, the maintenance allowances that have been...
Put on the microphone. Is it off? Yeah, okay.
The interim allowances, the order has been passed, white order dated 25/7/2024, Lordship, the first order. Then again, Lordship, after that, the appellant here has filed an alteration application, and white order dated 9/10/24, the court has passed the order to keep the said order in abeyance, Lordship.
So you're not paying maintenance now also?
No, Lordship. However, white order dated 11/8/2025, the maintenance has been revived back.
So where's the statement of account showing deduction?
Lordship.
See the last order.
Deductions. Lordship, cannot produce today, Lordship.
We're not concerned about what you submitted just now. That's already been submitted, correct?
Yes,
Only thing is that now we want to know, because what your colleague submitted last time is that he's taking home 200 rupees a month now.
Lordship.
That's what the submission. That's why I want to see the account statement, whether it's a fact. Your pay is 47,000, and after all deductions, they take 200 rupees home, and that's why the pen like whatever for litigation that they're asking should not be allowed. That's your case.
Yes,
That if the
yes,
further deduction is made, we left 285 rupees. So this court wanted to see, this is the first appeal, correct?
Lordship.
Then you wanted to see whether it's correct what you're saying, whether from your account from your bank account, your pay goes to the bank, correct? Or the deductions have been made from because submission was made that the office made the deduction, correct? Then where's the account statement?
Then what make time, Lordship?
Your Lordship, I have the bank statement of the respondent, Lordship. Nowhere is mentioned that the amount has been transferred to my account, Lordship. So as per the order 25/7/2024.
So then we'll just allow your appeal. Yes, let's see. How come he managed to get it and you couldn't get it?
There is no single transaction, Lordship, from the petitioners or appellant side.
The default is not from the part of the appellant, Lordship. It's because the court has not communicated the said order to the department, Lordship. For that reason, the Lordship, the department has not deducted.
Then why do you say you take 200 rupees back home? Your take home pay now, if deduction is allowed, then...
No, Lordship, if the alimony is... And 4 months, the area alimony has been deducted, Lordship.
Even in their appeal, Your Lordship, they have mentioned that 10,000 was deducted, Lordship. However, the amount is not being transferred to my account, Lordship.
The salary does not come to this account. It comes to this account as salary. I can't make out first. Just shows that
My salary is being reflected there, Lordship. It's only 6,050 rupees, Lordship.
oh, this is your account.
Yes, Lordship.
For petitioner, yes. Yes. Get it 1 week.
Lordship.
MS demote her. Not counsel for the appellant. Pray for the 1 week's further time to obtain the account statement from the bank or the office with regard to deduction made from the pay of the appellant towards payment of maintenance to respondent staff. MS NM Bank has also produced a statement of accounts of the respondent, which she submits, does not show any amount being credited by the appellant. Submits after 1 week. If that's the case, then we are throwing out your case.
Much obliged.
3. Item number 3.
Yes.
My lord, I need some more time, my lord, to find the address of the first wife, my lord.
May it please your lordship, I have received the address. I'll hand it over.
Mr. MS MR Marak, transportation submits that. What is the submission? That the address of the
first wife, my lord.
Of the first wife, namely Christina CH Marak, not been obtained. So as such, steps could not be taken. Ms. ASD, however, has produced the address and the same has been handed over to the petitioner. Steps with
Yes, ma'am.
For a step to be taken by the petitioner is within 1 week.
Yes, ma'am.
Necessary step, not problem step.
Yes, ma'am.
4.
Yes.
Lordship, we have filed a rejoinder and all the pleadings have been completed. The matter may come up in a hearing call.
Yes. Party submit the pleadings are complete. There's a matter of hearing and so on. So yes.
5.
Yes.
Obliged.
Please, Lordship. Lordship, I'm praying for some more time to file my rejoinder.
How many times you prayed?
With this second time, this is
Second time.
Yes.
2 weeks further time as prayed love rejoinder. So thereafter and so on.
6.
May please, Lordship. My lord, we won't be filing our rejoinder, so if this matter can come up for hearing after 2 weeks.
Yes, Mr.
But your Lordship, private respondents are there, 3 to 10. Private respondents are also.
They not appeared.
They're not appearing.
They've been served.
Yes, ma'am.
Let's see. Where's the factum of
3 to 17.
3 to 17?
Yes, your Lordship.
They've been served. Let's check.
Yes, ma'am. I'll just bring up the affidavit. Well, there's one affidavit on the 25th February 2026.
No.
That's only for 15.
Yes.
Yes, we got. But then
The others also we have.
note,
We have
only the 15 return unserved.
Yes, ma'am.
Then postal receipt has been received on behalf of respondents 3 to 17, the 26/9/25, and so you filed your affidavit on 25 to 20. They all served.
Yes, my lord. Order dated 13/11/2025.
Yes, Mr. A. The council submits that no rejoinder will be necessary. He praised the matter for hearing. With regard to the private respondents, it further submitted that though they all have been served, they have not appeared till date.
My lord.
So, this is the matter for hearing as prayed.
2 weeks.
In the interest of justice.
Yes, ma'am. 2 weeks.
This after 2 weeks, yes. Then when we start hearing it, we'll then go ex partes.
7.
Please, Your Lordship. Your Lordship, we have filed an affidavit.
Your Lordship, I'm praying for 2 more
You only
weeks.
prayed last time?
We
This is
prayed
the second
once.
time?
Yes, Your Lordship.
I prayed for the 2 weeks time and out the joinder. This thereafter also.
8.
File rejoinder.
Please, Your Lordship. Lordship, we have already filed our rejoinder. Pleadings are complete, my lord.
This party submit please are complete. This is the matter for hearing. Also.
2 weeks, Your Lordship. After 2 weeks.
9.
Offline.
I'm praying for a week's time, my lord.
Yes. For 2 weeks time as prayed allowed by affidavit. Yes.
10.
May I please, Your Lordship? Your Lordship, I'm praying for some more time, Your Lordship.
Yes, MS Ailingwa.
Similar prayer, Your Lordship.
Why? What's the problem?
Your Lordship, we have sought for clarifications. We are still awaiting, Your Lordship.
I'm just waiting for signatures, Your Lordship, for
Please, Lordship. Lordship, today is the 5th time. Respondents are seeking time to validate.
15th time?
5th time, Lordship.
5th time.
Your Lordship, this matter went for mediation. It was not settled.
See, he's got very strong objection. 5th time.
Lordship will be on board by the next date.
So you ensure that the affidavit is on board the next date.
I'll try, Your Lordship.
Ms. MS Ailingwa and also and you are for respondent number
6, Your Lordship.
pray for further 2 weeks time for affidavit. This prayer has been strongly resisted by Mr. Marmara. Our interest of justice, 2 weeks time crowd. Okay.
Yes. Deeply obliged.
11.
My lord, I'll be entering appearance for respondent number 5 as well. My lord, notice may not be required. I will just take for.
Implement application already came up on the 2nd of June.
They have corrected the name, so they have.
You filed a.
It came up on the 2nd of June, Your Lordship. The implement application. Your Lordship had allowed the application.
Allowed already. So I'll be appearing for that respondent.
Yes, sir. Mr. N. It's been corrected, court title.
Yes, sir.
Mr. N. Sinkon will be submits and he'll be representing the newly implemented respondent number 5. Such no for the notice required.
I'll seek 1 week time, my lord, to file the affidavit.
1 week's time to file affidavit. What about the other respondent? You already filed?
File your lordship.
Yes, like 2 weeks, yes.
12.
This is regarding the pending bill of the contractors.
Where's your application for implement?
I have filed your lordship.
Right.
Allowed.
Yeah, I've been allowed, your lordship.
Allowed.
Allowed. Oh, yes.
Now, my lord, this is regarding the pending bills. I think, my lord, there was some kind of negotiations, and in fact, university has technically sanctioned those amounts. So this is what first case.
Are you aware of that?
No, your lordship. I need to seek instruction, your lordship.
So unless my lord will make the payment, lordship can place it on the records. This is what number 1. This one. This is. This is all right. This is next.
Mr. SN was also appearing on behalf of the newly implemented respondent number 6. That registrar has submitted that the matter
this is 13.
The matter concerns payment of standing bill.
This is 13
to the petitioner, and in this regard, a technical sanction has already been issued.
This is what?
Wide letter dated.
And this is 13.
26.
My lord, I'm sorry. This is for 12, your lordship. So this is for 13 similar matters are there, madam.
10/6/26.
This is for 12. I don't know.
10/6/26. A copy of the same has also been produced. We'll close the matter.
Your lordship, I need to seek instruction, your lordship.
This matter, let the petitioner please without to obtain instruction. They give them a copy of the technical sanction letter dated 10/6/26. We made over to the petitioner. Yes. Next.
13.
Same order.
13 I have given, my lord. And this is 14, my lord. 14.
Copies of the letters are taken on board and made part of the record. Yes.
Give her copies. Give her copies.
15. 15.
Maybe please, your lordship. I have filed a report. I think it has accepted now. After 2-3 days, some correction.
Which report?
Inspection report was directed to be filed.
Yes, yes. What does it say?
I filed today.
Who's the petitioner?
Petitioner Chidikis.
43 persons were there as the petitioner, my lord. In their first report, they say only 33 are found at the place, and now in the new report, they say only 3 petitioners are there. Whereas for the survey, when they went there, it was their duty to notify all of them to be present in there. Without any notification, suddenly I don't know when they went there, and now they say only 3 petitioners are there out of 43. Whereas they are very much living there.
No, here is 7. No, I'm 7 persons staying, not 7 and 8.
7 persons, out of them only 3 are the petitioners, and other 4 are even not the petitioners. They are somewhere else.
They are?
So how it is possible, my lord? Only 3 persons will be there. Had they notified it, people will have been there. We have been waiting all along that when they will come for inspection. But we don't know even when they came there and how did they find that no one is there. There should be a survey.
Have you received a copy of this? Have you received a copy of this affidavit? You have received a copy?
Yes, sir. I am not satisfied with the survey report. Let them notify at least. We will be present there. No notification was ever issued.
No, it was notified. It was notified. Lazy were present.
No, Your Lordship, it was not notified. I just received a letter from the Cantonment Board to submit the copies of the tenants. So subsequently, I have submitted list of the tenants. After that, my tenants were 16 numbers. I have submitted the list of the tenants. 16. 1-6. Actually, it was 18, but 2 of them are having their houses in reserve. So I have deleted their names and I have submitted 16 of them. And I have the copy of the receipt from the Cantonment Board also. So what they are submitting is misleading, Your Lordship.
What about Mr. Kriam? How many people are staying there? You're another landowner there also, right? How many tenants you have in your property?
Your Lordship, may I, Lordship? Respondent number 7 and 8. Respondent number 8 is not affected at all. And he is having his own tenants and all, and he's enjoying the rent. Respondent number 7, partly affected. He is having around 40 numbers of tenants, and 20 of them have got gutted in fire, and 20 of them are still there, Your Lordship. So what my learned senior friend is submitting, hardly the 3 tenants are there, it's absolutely false, Your Lordship.
Whom we found only those 3 after inspection. As per the report,
only those. The site only 3 people.
Yes. No, they were present there. I can polish the record who were there.
No. Who were present there? Then how did you come to the number of 3? Did you say
yes, those who were present, those were recorded. Those who are present there.
No,
because most of them.
No, but you couldn't identify the structures and relate them to the people. If there are only 3 people, they don't have to be structures on that land.
Others
the pictures are pretty, a lot of structures have been raised, correct?
Yes.
So now if we see only 3 people were there, only 3 people raised all the structures.
Most of them left, Your Lordship. Went to any other places. We do not know that. That's what happened.
How will we close this matter then?
Yes, the record. I can produce the record. Who went there, who were there, everything. I can produce it.
It's false.
On the basis of the report.
You put an objection, then to this one, we'll close the matter, we'll hear it. You produce the records next day.
Yes, I'll produce it.
Yes. An affidavit in compliance to the order dated 18/4/2026 have been filed today, containing the inspection report. The same is contested by the respondent number 6 and also 7 to submit that the report does not reflect the correct number of tenants present in the land. Interview the matter, they permitted to put in the objections. Just after 1 week, Cantonment Board produce the records the next date. Yes. Otherwise, never end.
Yes. Because most of them left, but I don't understand what they're saying.
We have our district judge to go and do the section then.
That's it. Better. Much obliged.
My lords, in item number 16, the state is supposed to file the affidavit, my lord. Lordship, in this case, your lordship, while going through the records, we find that there is a representation of January 2026.
Last time you had made a statement that after we find the course of the day. What happened?
No, that was not. It is in connection with item number 17, your lordship. Because they are both more or less connected from the same department, your lordship.
Different rank.
What happened?
We have filed our affidavit in 17, your lordship, in course of the
What
day.
happened?
No, in this case, your lordship, I was making a prayer that since there is a representation, that representation may be disposed of. My lord, with respect to my learned senior submission, my lord, I would just like to humbly submit that this matter has gone to the Lok Adalat also, my lord. And then further, they had come with some instructions from the department, my lord, but yet they are to receive some more information regarding this matter. And this matter is again called for the Lok Adalat on the month of September, my lord. Which is it may be disposed of.
September, the long way away.
Yes, my lord. My lord, kindly don't
Where's the representation? Is it the next
This is
year?
the next year. It is the next, my lord. But my humble submission is that, my lord, kindly, my lord, let them file the reply, my lord. Let them file the reply, my lord. It won't be fruitful for disposing the representation, my lord.
Okay, though MS Yangi B. Leonard AAG has submitted that the representation from the petitioner is pending consideration. Our MSS now said the counsel for the petitioner has submitted that would be
Fruitless exercise, Lord.
fruitless exercise. And she prays that the matter be heard after affidavits have been filed. Accordingly, how much time require?
2 weeks time, your lordship.
2 weeks time.
Oh, 3 weeks time, your
2
lordship.
weeks time
Because
allowed to respond to file affidavit.
my lord, item number 17, my lord, is the connected
Here we
matter.
have filed our
And I'm supposed to file my rejoinder, my lord. So I pray for
17 is 17 in this matter. MSS now said prays for. It's allowed 2 weeks time for rejoinder. It's list after 2.
highly obliged, my lord.
Obliged, your lordship.
18.
But there's some developments. They've terminated the contract, my lord, in this. So I'm praying for just maybe three days time, my lord.
You all succeeded circumventing the orders of the court.
No, my lord. No, it's not termination of contract, no, it's cancellation of letter of award.
Termination of the contract by MEP DCL, my lord.
Copy.
We will place it, my lord.
Yes,
One week we will examine
This has
that.
become infructuous, my lord. This
Dr.
petition has
Mbodika
become
submits
infructuous.
that he has been informed that the engagement of the petitioner has since been cancelled.
Yes.
He may place us. Where's the cancellation letter? You have it with you.
9th June 2026 order, my lord. 9th June 2026 order.
You all left the place.
No, my lord, we are still there. We received yesterday evening, my lord. I have not received an official communication also. Just yesterday morning, it came out in newspaper, my lord.
This is the matter after 1 week for order.
19.
Let them get material instructions.
It's difficult.
Joseph, I need some time, Julius, to file my affidavit.
Time for
filing affidavit.
Affidavit, your honor.
Yes. For the 2 weeks time at the law affidavit, yes.
Blood.
20.
I pray 2 weeks time for filing a rejoinder, lordship.
What is your name?
A. Bora.
MS Bora for his petitioner prays for allowed.
Interim order is also there, lordship.
Two orders for rejoinder. Interim order we need to continue. The next date is
21.
Highly obliged.
My lord, in this matter, I was directed to file an affidavit. I have filed my affidavit today, my lord.
I have received it.
You want to file rejoinder?
Yes, lordship. I'm praying 2 weeks. And with regard to the respondent number 4, I have filed the affidavit on service, lordship.
When did you file it? Today?
No, I have filed on 7th of May.
7th of May.
Lordship.
Yes, sir. MS Mr. SD submits affidavit since been filed. Stop. Next paragraph. This L coach concept petitioner submits that the prays he allowed to file rejoinder within
2 weeks.
2 weeks. With regard to respondent number 4, an affidavit has been filed indicating service upon respondent. Accordingly, all notices are complete. It's after 2 weeks for rejoinder and for appearance of respondent number 4.
Highly obliged.
22.
Lordship, we are filing our affidavit in course of the day, your lordship. 1 and 2. For 1 and 2.
What about 4? What about 4?
We will
We have to take steps.
could not obtain the correct address of the respondent number 4.
Then-
We are on the process. I may be allowed to grant some more time, your lordship.
This is actually.
Common song only, you can't find the address.
No, your lordship.
Yes, so what you're submitting?
No, this is under the Surfacy Act, Your Lordship. So there is an alternative remedy also before the Debt Recovery Tribunal. So we've taken that plea, Your Lordship. We'll be filing a
Yes.
affidavit.
Have you filed it or not? Affidavit.
On course of the day, we are filing.
MSP Yangi Leonard AAJ for respondents 1 and 2. Submit that affidavit be filed in the course of the day. None appears for the respondent number 3. Do they will serve, right? 3. With regard to number 4, MS, your name, sorry?
Srimati R. Paul.
Yes, MS.
Somebody had
R. Paul, please allow for the 2 weeks' time to file, to obtain the correct address and file affidavit. And take steps. Yes.
23.
May I please, Your Lordship? Your Lordship, the conducting counsel S. Marpan is in bereavement. His maternal uncle passed away, so kindly fix this matter after 2 weeks, Your Lordship.
Has the amount been verified or not?
He haven't instructed me, Your Lordship.
Matter come after 2 weeks since he's in family bereavement.
Yes, sir. As reported that the conducting counsel we have respondent number
3.
3.
3 is in bereavement just after 1 week.
Okay.
Much obliged, Your Lordship.
24.
File affidavit.
Your Lordship, they filed an affidavit bringing on record a communication that states that the promotion of the petitioner is under process. Your Lordship.
So
Your Lordship,
direct them to finish it up within.
Your Lordship may kindly appreciate that the respondents only initiate action after a petition is filed in the court. Your Lordship.
So
I'm praying. Your Lordship, I'm praying let the matter come after 4 weeks, Your Lordship, giving them time to complete the process.
Yes, and after Dr. Mbozika's affidavit has been filed when indicated that the promotion of the petitioner is being processed up. MS the opinion, please the matter with him of 2 weeks. Yes, for further orders.
3 weeks, right?
Over 3 weeks.
Right, Your Lordship.
Second call, supplement 2.
What is this?
Lordships, the petitioners are working as Havildar clerk, Lordship. Then they were redesignated as warrant officer.
They were working Havildar clerk, then redesignated or
yes,
demustered? No.
Redesignated as warrant officer, Lordship.
Yes.
So, Lordship, they have been working for almost 18 to 19 years, stagnant in the same post, Lordship. They were due for promotion to the next promotion post, that is Naib Subedar. Lordship, at page 71, a promotion order has been issued, Lordship.
Yes.
So, Lordship, can you come to page 71? Promotion order, Lordship.
Yes.
Lordship, the petitioners herein are placed at serial number 1.7 to 1.21, Lordship.
Yes, okay.
Except 1.16, he is not come, Lordship.
Okay.
So by this promotion order, Lordship, 31st December 2025, they have been granted promotion to the post of Naib Subedar with effect from 1st February 2026. Then, Lordships, thereafter, at page 76,
yeah.
Lordship, this is a cadre review in respect of Group B and Group C post, Lordship. Lordship, in the first paragraph, Lordship, can you see? It is intimated that the cadre review of Group B and C post of Assam Rifle has been approved by the MHA New Delhi by their file numbers also dated 14 Jan 2026. So, Lordship, on 14 January 2026, there is a cadre review which has been taken by the MHA, Lordship. Now, because of this, Lordship, at page 78, the promotion has been kept in abeyance.
Yes.
The promotion dated 31st December 25 has been kept in abeyance. Now, thereafter, Lordship, at page 81, Lordship,
Yes,
At page 81 now, they have cancelled that promotion order, Lordship.
Why? On what ground?
On the ground of cadre review, Lordship. And one more thing, Lordship, at page 71, the promotion order, Lordship, the first 6 person have been granted promotion.
How is that possible?
So our contention is that cadre review cannot be a ground for denying promotion, Lordship.
Yes. Ye to mujhega.
But kindly see page 88, madam.
Yes.
This is to para 3, madam. The above promotion order for the month of January 26 has already been implemented. However, the promotion order referred to in para 1.7 to 1.21 pertaining to petition as well was kept in abeyance by Directorate Letter number so-and-so dated 29 January 26 and was subsequently cancelled consequent upon approval of the cadre review of the force on 14 January 26, wherein the promotional vacancy for the rank of Naib Subedar Clerk have been reduced to 278 should be from. So there has been downsizing, my lord. And because of downsizing now, because the cadre review order itself says, my lord, those who have already been granted promotion, because first 6 of the promotion order, my lord, because they were promoted with effect from 1st January 2016, my lord. So they have been retained because some kind of vested right accrued.
So what is the difference between those 7 and?
Because their promotion to take effect from 1st of February, my lord, and before that
2026.
2026.
And the others from 16.
1/1/26.
January.
They're 1st January, they are from 1st February, my lord.
So the cadre review came when?
January, my lord.
14 January 26.
So that has taken away the right to be promoted.
That's our case, my lord.
But is that sustainable?
Because so far as the rules are concerned, Your Lordship, they are governed by the
grant of order, they are with civil consequences.
Lordships.
Then
But they have to sanction posts.
they'll acquire some.
They have to sanction posts as well.
How can it be such a drastic, reduction from 656 to 78? You must be having fallout in all the other branches also.
Other branches also.
Then what is the logic behind downsizing?
Yeah, my lord. The clerks, my lord. The clerical jobs that have been carried out by.
So now you're using AI is taking the job of half of the people who are supposed to get jobs.
Well, I have instance in affidavit, my lord.
Yes, sir. Then it's counsel for the petitioner. Issue notice Dr. Edinburgh's College GCI with MS Sijala. Is present, no further notes required on the respondent stop. Next paragraph. Mr. Edmund Ompure, legal counsel petitioner, submitted that the grievance of the writ petitioner is with the withdrawal and cancellation of the promotion order dated
31st December 2025.
31st December 2025, where the promotions to the post of Naib Subedar
Clerk
has been cancelled, though from the same list itself, 6 personnel have been promoted. So, he therefore, it's obvious. Next paragraph, Dr. Mozikala GI appearing for the respondents has submitted that in view of, does cadre review have any link with this?
It's carried with examine the strength, my lord, how much strength is required in which branch. Is done periodically.
Cadre review can even do for doing away with certain posts.
Certain posts are abolished also.
Dr. Mozika submits that in view of the cadre review exercise that was undertaken by the respondents, the post of Naib Subedar bracket clerk has been reduced to 278 only out of 656 vacancies, and is on this ground that the promotion order should cancel. So, what other submission do you have?
File affidavit.
He prays it out to file an affidavit within
3 weeks.
3 weeks. Yes.
Bishop, I have an interim prayer.
Interim prayer.
To stay the cancellation order and not to fill up the 14 posts, Lordship.
There is no question of filling up.
There are 14 posts that still remaining is vacant. How many?
Because that is the controversy, Your Lordship.
No,
Because
now the
their
thing
ground is that the
okay,
vacancy
another
have been
thing
reduced.
I mean, your submissions apart. 278 posts are there. How many have been filled up?
Because I'll need it, but it appears, my lord, 278 with those 6 after retaining those 6, my lord, those who joined from 1st January 26. I think all are filled up, and that's why this order has come, my lord.
I'm praying for some protection.
What
Otherwise,
protection we get now?
Lordships, they might carry out some.
We're not filling up.
We're not sure, Your Lordship. This number,
up,
this
that
number is not
direction
sure.
can come, my lord, because I don't think
Yes,
there is any attempt to fill up.
It is in view of the circumstances of the case directed that till the next date there shall be no filling up of promotional post Naib Subedar.
Lordships.
Clerk, in case this Naib Subedar go to another trade.
The concerned post, the concerned types of other post, because there may be some other post, I don't know.
I said clerk.
Hello, Lordship.
3.
Three, Lordship, this pertains to remonstration, Lordship. This is the 4th or 5th round of litigation.
5th round of litigation, why?
Lordship, in every matter that is filed before this court, Lordship, the respondents were directed to dispose of the representation. Now, even in this matter, Lordship, the impugn order, which the speaking order passed by the respondent, has not really addressed the issue of remonstration, because our ground is that remonstration is one of the mode for it's akin to direct recruitment, Lordship. So that issue has not been dealt, Lordship, because the rules is there, Lordship, and as per the rules, Lordship, the Assam Rifle has the power to relax the rules, Lordship. Their case is that he is not eligible for remonstration because the rules does not prescribe, because the post of Naib Subedar is for by way of promotion, Lordship. So now we had submitted ourselves that the rules, the power, the Assam Rifle has the power under the rules to relax some clauses of the recruitment rules, Lordship. So that also has not been considered in the representation.
Relaxing the rules only in a very emergent situation.
But this case has gone in a different direction, my lord. If I may just take a Lordship's last order, my lord, page 143. This is of February this year, my lord. 143.
143.
My lord. Well, I'll read from para 3, my lord.
This is my judgment only.
Yes, my lord.
Yes.
Dr. So-and-so, in reply, has submitted that for the said post in question, there is no provision for remonstration and the post is only to be filled up by direct recruitment. It is further submitted that in a similar matter which appeared before the High Court of Manipur, a single bench by the order dated 10/10/2019 passed in WBC number so-and-so had allowed the prayer of the similarly situated petitioners and directions were issued for remonstration with effect from the date of completion of diploma course, but that this order was taken to appeal before the division bench. In the appeal, it is submitted an order dated 2/4/25 was passed in WA number 20 so-and-so and in another connected matter WA number so-and-so, whereby the respondents were directed to consider the representation of the petitioner and to pass appropriate orders in accordance with law. The matter he submits then traveled to the Supreme Court and by order dated so-and-so, the SLP filed against the writ appeal is to dismissed. He therefore submits that the petitioner being similarly situated, no relief can be forthcoming. Mr. M. Chanda, learned counsel for the petitioner, submits that though this position may be correct, however, the matter was never gone into on its merits and perhaps the writ petition may be given the same allowance as given to the similarly situated petitioners in the writ petition that was disposed of before the Manipur High Court. The same is not objected, so this court, on a hearing of the learned counsel for the parties and considering the materials which have been placed, especially the court's order of Manipur High Court and the Honorable Supreme Court order, without lingering with the matter, considering the situation of the case and the fact that the respondents in the other cases have been directed to consider the representation. In view of this court, the same concession can also be afforded to the writ petitioner hearing. Accordingly, the writ petition is disposed of with direction to the writ petitioner to file a representation and to dispose of the representation. Then the representation has been disposed of, my lord.
Where's the order?
148. We've always maintained, my lord, this particular post is meant for direct recruitment under the rules, my lord, and it cannot be filled up by either by promotion or by demonstration. His only case is, my lord, that he took study leave to undergo a particular diploma course, my lord, and that gives him a right to appointed to this particular engineer's post.
What study leave?
For some diploma in civil engineering, my lord.
Diploma training, Lordship. Engineering at CME, Lordship. Civil engineering, Lordship, diploma. which is one of the criteria also, Lordship, for into direct recruitment. Possessing of a diploma in
So you
civil
want them
engineering.
to exercise extraordinary power to, I mean,
So
that
under Rule
exemption-
6, under Rule
that
6
to
of the
relax that clause.
Lordship.
and accommodate you.
Because in-service
Lordship.
candidates can only resign and apply fresh, my lord, for a direct recruitment.
File affidavit then.
Lordship, for 17 years he's been working in that post.
That's very good. Everyone works that way.
Lordship, and Lordship, in the speaking order, they have relied on the Manipur judgment, Lordship. Manipur judgment has not even gone to the merits of the case, Lordship.
Yes,
So it requires consideration.
Issue notice, Dr. Ambrose Kavuri and Sijala. Present, no notice required other respondents. This after 2 weeks for affidavit.
Lordship, this is an interim protection because they might revert back, Lordship.
No, he has to go, my lord. He cannot.
Because
What
this
he
matter
has to-
requires
whether
consideration, Lordship.
whether-
Whether
Yeah, it's a fishing expedition. Now, because you attained other qualification, you're saying that they're on two contingencies. That fine now, like it might be by direct recruitment, but the thing is that now I've attained the specialization, and so the PP should consider me by relaxing a clause in Assam Rifle rules to accommodate me in direct recruitment.
Lordship, in similarly situated case, Manipur has granted stay, Lordship. I'm placing this order, Lordship, on similar set of issues, Lordship. Stay has been
It will
granted.
not be. I don't think it'll be on a proper understanding the matter.
Lordship, because
With due
he'll be,
respect.
Lordship, he'll be reverted back to his original
No,
position,
he has to
post
go back,
Lordship.
my lord. This is 2019 order, my lord.
This is stay operating, Lordship.
No.
I have the
After
latest
that, so many
order.
orders and parts
I have a
have
latest
gone to
order,
Supreme
Lordship.
Court also.
It's been fixed. It's fixed on 12/8, Lordship. The matter, Lordship. This is the latest order.
List the matter after and for the
Lordship,
order considered next.
On the
day.
next day, Lordship.
Otherwise,
Hearing. Lordship.
25.
if only a direct injury, then the court or prima facie case made out, then the court will give interim orders. If it's
Lordship, because
you interpolate it with other considerations.
pursuant to the speaking order, the Lordship, they'll issue the reversion order.
He has to go back. He cannot be there permanently.
Yes.
Hearing 25.
This is
Yes. You ready?
Yes.
Yes.
This matter was hard, my lord. Only we are supposed to place the judgments. And can it be placed physically, my lord?
After 1 week.
Because
Okay.
the facts, after a week, my lord.
On a prayer or a contemplation, it's a matter of 1 week.
Let it be after 2 weeks, my lord, because next week full of matters are there, my lord. Before my lord only, my lord. All Nehu matters.
Nehu matters? Yes.
Nehu matters, my lord. With Mr.
Yes.
Sam.
It's all right, Your Lordship. It's their case, Your Lordship.
27.
Yes.
27.
Here also, my lord, the matter was heard, my lord. Only we need to take the judgment where the
What matter is this?
boy. This is the matter where, my lord, the boy was not allowed to join his service because he was shown to be arrested in a wrong case, and later on, subsequently, my lord, he was discharged from the allegation.
Has been heard at all? I don't think it's been heard.
It has been heard, my lord. Mr. Dev has argued a matter. So we were supposed to place the judgment only, my lord, that whether now this boy can get back the job or not, my lord.
Your
There is a
Lordship, if the
judgment
matter is taken up, I pray that it may come at the end of the board. Mr. Shulai is on legs.
He's praying for
Let it
time.
come after 2 weeks. Let it come after 2 weeks.
Yes. Same order.
Obliged, Your Lordship.
28.
Please, Your Lordship. Lordship has to come, respondent has to come with instruction, Your Lordship.
Respondent's instruction. This is the NEPA contract, my lord. There is some admitted amount and some undisputed amount.
His Lordship, during the course.
So you take the undisputed amount?
No, Your Lordship, we have, with regards to the Lordship has directed us to come with the instruction, Your Lordship. We are saying that we are not taking the disputed amount, Your Lordship. We will not
Undisputed amount.
use
Take
our
the undisputed amount.
Lordship. Because, Your Lordship, during the course of hearing on the last occasion, Your Lordship, my learned senior has placed one documents, Your Lordship. That is Annexure 8. On page 28, Your Lordship. Annexure 8.
Of the writ petition?
Yes, Your Lordship. With regards to this, Your Lordship, the respondent has to come with instruction, Your Lordship. Because this is sanction order, Your Lordship.
Type copy is at page 29, Your Lordship.
Type copy is there?
29, Your Lordship. 28A, my apology, Your Lordship. Even though it's even though it is not recorded in Your Lordship order, Your Lordship.
This is a sanction.
Yes, Your Lordship.
Now, the thing they were holding your bills, correct?
Yes, Your Lordship.
Yes, yes, Dr. Muzika.
My lord, after this, there was a sanction at some point of time, my lord.
The sanction letter was done as far back as in 10/5/23.
Yes, my lord. But after that, it was discovered, my lord, that he has not completed the work. The quality of work is very bad, my lord. And then he was issued further directions to complete the work, which he has not done, and then come to the Honorable Court.
Now work's been rectified, so what remains?
What has not been rectified, my lord?
Lordship, that's what they say, Your Lordship, because there are several board of proceeding has been held in this issue, Your Lordship. Despite this sanction order, Your Lordship, several board of proceeding has been initiated.
See, I just made a note last time, yes. Now board proceeding of 4/23 satisfied. Sanction for payment made on 10/5/23. Then request for payment was made on 2/6/23.
Yes, Your Lordship,
then letter asking for ratification 15/6/23. Then 26/23 work rectified. Then next year 8/12 board proceedings 18/7/23. Then rectification requested 24/7 rectified.
Yes.
Then
it's not been rectified, my lord. That's what they are saying, my lord.
You can't hold contractor forever.
But that's what I was praying, my lord. There is some disputed amount because undisputed amount is two-thirds of the amount, my lord.
Once you take undisputed amount and the undisputed amount, you fight it out.
But it's been instruction, Your Lordship.
You don't need the money.
No, Your Lordship, we are not willing to accept the disputed amount, Your Lordship.
No, they may not.
No, not willing to accept a disputed amount, not willing to accept an undisputed amount.
No, Your Lordship.
The sanction for 26 lakh, correct?
Yes, Your Lordship.
That should be your money, right?
Yes, Your Lordship.
So what amounts undisputed for the work?
About
done?
18 lakh.
Yes.
Have
you measured the work?
Yes, ma'am.
Your Lordship, the latest, this is spot inquiry also, where I am not present, Your Lordship. Spot inquiry, Your Lordship, to the work. And I have not been served with a notice and I am not present in that.
When is the last spot inquiry done? When is the last spot inquiry?
Well, this matter will come because they missed out in the cause list.
Yes,
The file is not here.
Dr. Muzika praised for 1 week for it. 1 week sent opinion instructions, yes. Otherwise, you take the undisputed amount, something better than nothing, yes?
We'll seek instruction to that, Your Lordship.
It's not that you take it, that means it's without prejudice. It's not a question that you waive your right to dispute the amount which are due to you.
I'll seek instruction to that, Your Lordship. I will match, Your Lordship.
Yes.
30.
We're going to see it in type class here. Kembang I can type off that. Yes.
Notes. You start your own first.
Pardon?
You start your own first. There are cross appeals, my lord, against the same. So one is filed with the department, MES, my lord, and one by them. So they will start there.
Start. Item number 30 is which one? RFA, however.
If number 6 is this, my lord. And 9 is department.
6 is?
6
is our.
Start.
Yes, may I please, Your Lordship. This appeal is on a limited point regarding the jurisdiction of the court. Whether the court, while dealing with an application under Section 30 and Section 14 and 17 of the Arbitration Act 1940, could have modified or clarified an award. In this case, Your Lordship, there was an award which was passed and award is dated
when 2013, the award was passed in 2013, my lord. And that award has been made rule of the court. I am not going into the other background of the case.
This is this 940 Act.
1940 Act.
Yeah.
Well, earlier the award was made rule of the court, where department failed to contest, though they filed objection under section 30, and since they failed to contest, appear on the date of hearing, the matter was heard ex parte. But even then, the trial court did take into consideration the objections filed by them and found no merit, and then the award was made rule of the court. No appeal was filed by them. Then we had filed for execution. Execution was, in the execution, court directed to pay, the notice was issued to them. They gave some objection in the execution. That objection was heard and rejected.
What is the amount involved?
2 crore something with interest, it is coming. Yeah. Anyway, department has paid the entire amount, which was allowed to be withdrawn, with 50% to be kept in fixed deposit. At that time, they have filed the appeal, which was barred by limitation. During the pendency of the execution, appeal was filed, which was barred by limitation. And then limitation was rejected by the appellate court. Against that, they came by a revision before the High Court. The Honorable High Court, the Honorable Chief Justice, while taking up that matter, directed that the ex parte order by which the award was made rule of the court, that will be set aside, and the appellate court will also hear the section 30 petition. And first, the ex parte order will be set aside. That order was not very clear. However, at the time of taking up this matter by the appellate court, as per the direction of the Honorable High Court, without hearing on merit the appeal, just set aside the earlier order of making the award rule of the court. And appellate court took up the petition under section 30 and 16 and 17 filed by us for making the award rule of the court. Now, the court, after hearing both the parties, allowed our petition under section 16 and 17, made the award rule of the court. And in that order has also directed that the terms of the award will form part of the decree. However, the trial court went one step ahead and clarified the award, in the sense by that she has, so far as the interest post-award interest is concerned, that the trial court has clarified that will be only on the awarded amount and not on the total payable amount. So this clarification. Now my first submission is, Your Honor, even the section 30 petition filed by the department, the trial court, after hearing, rejected the section 30 petition to set aside the award. Their petition was rejected, award was not set aside. And in that petition also, court has clarified that, however, the post-award interest will be calculated only on the awarded amount. Now the whole issue here is only with regard to that, whether the trial court was right, could have, while exercising jurisdiction under section 30 and section 16 and 17, could have clarified the award, whether that is permitted under law, Your Honor. Firstly, if court is satisfied that there is no ground to interfere with the award and set aside section 30, rejected section 30, upheld the award, whether court could have again clarified and touched the award and changed the terms of the award, my lord. Your Lordship, I will just take your Lordship to page number 80 of my memo of appeal. Page number 80, my lord. This is the operating portion of the order. The petitioner's case is decreed as follows. The instant case, page number 80, my lord, 80.
Yes.
The order portion. The instant case is decreed on contest and the award dated 5/9/2003 passed by the sole arbitrator in contact agreement number such and such is made rule of the court. Award is made rule of the court. However, it is clarified that the post-award interest of 15% shall be calculated on the awarded amount and not on the total payable amount. So whether this part, whether clarified, once you make the award rule of the court and then clarification, which is not permitted under law, The petitioner is awarded interest at 17% on the principal amount from the date of the decree till realization of the entire decretal amount. Union of India shall pay the decretal award amount within 60 days from the date of the decree. The terms of the award, again the court is giving terms of the award dated 5/9/2003 shall form part of the decree. Draw up the decree accordingly. The terms of the award without any change, the entire terms of the award is forming the decree. Then where is the scope of again going into clarifying the award but the interest part will be? That is wholly not permissible under law, Your Honor. This is where how we have challenged this order. And then even while rejecting section 30, my lord, if your lordship will come to the last page, 147, both the matters were heard together, and in their section 30 petition, my lord, last page 147, conclusion, in view of what has been discussed above, this court finds no reason to interfere with the findings of the learned arbitrator. Last page, my lord.
You go to 147.
In my copy, it is 147, my lord.
Yes.
Last.
Yes.
Yes. Conclusion. In view of what has been discussed above, this court finds no reason to interfere with the findings of the learned arbitrator. And the award dated 5/9/2003 passed by the sole arbitrator so-and-so is hereby upheld.
Yes.
Except that the post-award interest of 15% shall be calculated on the awarded amount. Now, this exercising this jurisdiction is beyond the jurisdiction of the court hearing a petition under section 30, and this is not permitted. Either court cannot modify or clarify the award. Since there is no ambiguity in the award also, only thing court has to either set aside the award or make it rule of the court. My lord, now so far as I'll take your lordship to the awarded portion. Now we are here aggrieved only with this this portion of the order, which is totally illegal and cannot be upheld in law. You know. Now your lordship will kindly see even then so far as whether the interest on the awarded amount on the clarified that the post-award interest shall be calculated on the awarded amount and not on the total payable amount. Now, what does the award say, my lord? If your lordship will kindly turn to page 39. Page 39. This is the relevant portion of the award which is concerning this case now.
Page 39.
Page 39, my lord.
Claim 7 and 8.
Claim 7 and 8. So, after considering arguments of, may I read from here, your lordship? After considering arguments of both the parties, I found that the claimant signed the final bill on 5/2/94 and arbitration was invoked on 5/3/94. The claimant should have been paid all their dues within 6 months of signing of the final bill, and the arbitration was invoked on 5/3/94. Therefore, the claim is due from 5/10/94. Therefore, I award simple interest on the total awarded amount under claim 1, 2, 3, 6 and 10 at the rate of 12% per annum from 5/10/94 to till the date of signing of the award. So, my lord, this comprises, that is, pre-reference and pendency light interest. I further allow Union of India a period of 90 days from the date of signing of the award to pay the amount to the contractor so-and-so in terms of the award, and failure to do so, the Union of India is directed to pay further simple interest at the rate of 15% per annum on the total payable amount in terms of the award from the date of signing of the award to the date of release of payment. So this second part involves post-award interest. First part is pre-reference and pendency light, and second part will be post-award interest. And arbitrator has consciously used the term, Your Honor, while awarding pre-reference and pendency light interest, arbitrator has clearly written simple interest on the total awarded amount. All the amount that is awarded under 1, 2, 3, 6 and 10, on those simple interest on the awarded amount. But while granting post-award interest, again arbitrator has used it, has not said ki 15% on the awarded amount. He has used the term on the total payable amount. That means if A is the principal amount under all the claims, B is the pendentylite and pre-reference interest. So on total payable amount will be on A plus B, whatever is the total amount, 15% interest on that for the post-award interest. And that is the way it is calculated, it is done in every commercial transactions, also in every arbitration, in every award, it is calculated. Now, on this basis only it has been paid, calculation has been done that post-award interest is on the total payable amount, that is A plus B, principal plus interest for pre-reference and post-award.
And post-award?
Post-award interest. Now, whole confusion arose, Your Lordship. One judgment of Justice, one D. Khosla's judgment was there. Now, relying on this D. Khosla's judgment, the court has changed the terms of the award, which was beyond the jurisdiction of the court. Firstly, my lord, that court could not have done that, sitting in the capacity of a court hearing section 30 and 1617, my lord.
Yes.
You've given the list of this document. Court has relied on this D. Khosla judgment, but before that, my lord, I would just like to take your lordship's notice. At the time when the execution was filed, we did our calculations on the basis of the award, which was being made rule of the court. Same way we calculated principal amount under different claims, that is A. Then pendentylite and pre-reference interest 12% on those claims, whatever amount has come, that is plus B. Then for post-award interest, we calculated
the total amount
on A plus B, on the total payable amount. Thereafter, the court has granted us post-decree award. When the award was made rule of the court granted post-decree award at the rate of 17%. So that was calculated on the decretal amount. So your lordship, decretal amount will be A plus B plus C is the decree court has passed. And court granted us interest at the rate of 17% on the decretal amount. So decretal amount, we have to include all A plus B plus C, whatever is granted, whatever has been made the decree. It was calculated on that. Now, Union of India, in the execution, they filed objection. They said that their case was that interest of post-award interest should be calculated not on A plus B, only on A, on the principal amount. And that submission they made relying on the judgment of D. Khosla. That was argued before the executing court. After hearing, taking into consideration of that judgment also, that executing court rejected their objections. That is, and has clearly given her finding also, that is at page 59, your lordship. At page 59, the same presiding officer who was acting as the executing court, after hearing on earlier occasion, has given the finding here at page 59, your lordship, para 10.
Yes.
This court is also not in agreement with the submission of the learned counsel that the interest of 15% is to be calculated on the principal amount. The award which was made rule of the court clearly states that the interest of 15% per annum has been levied on the total payable amount. Therefore, the calculation for the payment is to be made as follows. Court is giving the calculation also. Total amount due from this to this is to be calculated at the rate of 12% on the principal amount of rupees 19 lakhs plus, as adjusted by the award and confirmed by the decree. Total amount due with effect from 6/9/2003 till 17 October 2018, that is post-award, is to be calculated at the rate of 15% on the total amount arrived at A plus B, and the total amount due with effect from till payment is to be calculated at the rate of 18% on the total amount arrived at B. Court is also giving the calculations that how we calculated, rejected. But, and accordingly, this order, this finding of the court, executing court, was not challenged by Union of India.
Read para 9 also.
But what is the finding of the court? I can read. It is clear that the language in the award and the interest has been levied on the principal amount. The subsequent interest has been awarded on the total sum payable. It is settled position law that executing court cannot go behind the decree. That is a settled position of law. That is, but court has rejected and directed to pay this. They did not challenge this finding of the calculation of the court, and they deposited that amount without any
total amount ABC.
ABC, how it is calculated, how we calculate, how it should be as per the terms of the award. It was deposited without any reservations and we were allowed to be withdrawn. But subsequently, when the matter came up for the, again as per the direction of the Honorable High Court, again when section 30 and 1617 was taken up by the same presiding officer as a court for first instance, relying on the D. Khosla's case, she has changed the Honorable Court has changed the term of the award by clarifying the award, where there is no scope of clarification, giving clarification. Now, there is no ambiguity in the language of the in the award, what arbitrator has awarded. Arbitrator has consciously used two different terms while awarding the interest. For the first part, he said 12% on the awarded amount. In the second part, he said 15% on the total payable amount. He did not use the term on the awarded amount. Had it been, if arbitrator would have awarded us that 15% on the awarded amount, we would have been entitled to that only. But it is the arbitrator's discretion how he wants to give the award, at what rate he wants to give interest, and for which period he wants to give it. That is totally within the discretionary power of the arbitrator. And arbitrator in this case, very consciously, he has used two different terminology, and there is no ambiguity at all which call for any clarification by the court. And besides that, clarification is out of the jurisdiction of the power and jurisdiction of the trial court taking up this matter under section 30, my lord. Now, that D. Khosla's case, we have given the list of books if it is available. That this is 2024 9 SCC 476. Well, this case, which the trial court relying on this case, has given this impugned judgment. This is totally distinguishable from our case, and it will not be applicable in this case. Your Lordship, if your Lordship will kindly turn to, I'll just go to the operating part. In this case also, the Honorable Court has discussed the case laws at page 20 in Oil and Natural Gas Commission case, State of Haryana, as para number 20. Well, I'm not reading, I'm just saying, my lord, in this judgment, the Honorable Court has also relied on these cases, para 20, 21, 22, 23, which are the authority on interest, my lord. And then come to the finding para 25, my lord. Para 25, I'll read. Neither the Act specifically empowers the arbitrator or the para 20.
In view the above.
Para 25, my lord.
Yes, in view the above.
Oh, my lord, I know the para number may be changed because that is.
What do you give me then? Give me the correct one. Reading yourself, see online, giving the court some printout.
No, we did not give printout. We gave the course.
D. Khosla.
Yes, we gave the list of books only. We have another D. Khosla, no? We have another D. Khosla.
See online.
You'll also get this one?
No, I have some, I don't know from where.
I have this copy. Original printout from someone.
The two D. Khoslas were there, no?
You're reading from PCC online. Para may not match.
Huh?
Para may not match.
Give me one. Huh? Oh. You have given this one? Okay. Then let me see in this one. It will be para 24, my lord, in this one, in your lordship's copy. Para 24. Neither the Act specifically empowers the arbitrator or the court to award interest upon interest or compound interest, nor there is any other provision which provides for grant of compound interest or interest upon interest. Even Section 34 CPC is silent in this regard, whereas subsection 3 of Section 3 of Interest Act specifically prohibits the same. In view of the above legal position, we have to examine the award in question and the decree drawn in pursuance thereof to find out if compound interest or interest upon interest has been awarded. The relevant part of the award pertaining to the interest and that of the decree has been reproduced herein before. A plain reading of the aforesaid award and decree reveals that interest awarded under the award has been dissected into two parts. The first part relates to the pre-award period from the date of completion of the work till the passing of the award, whereas the second part is the post-award period commencing from the date of the award till satisfaction of the award. In the first part, simple interest at the rate of 12% per annum has been awarded on the amount awarded, whereas in the second part, interest at the rate of 15% has been awarded, referring to the amount awarded. So the amount awarded in both situations have to be the same and cannot be two distinct amounts. So your lordship, in this particular case, the arbitrator has awarded 12% for the first part on the amount awarded. And for the second part also, arbitrator has very clearly written on the amount awarded. But in our case, it is not the case. Here, in the award, the arbitrator has clearly mentioned in the second part, it is on the total payable amount, and first part is on the amount awarded. So this could not have been, because here, obviously, if the amount awarded has to be the same on both, for both the period. But in our case, for the second period, it was not amount awarded, it was the total amount payable. That is how it is distinguishable, and this case was not applicable in our case, your lordship. Now, the amount awarded refers to the principal amount of compensation awarded, that is 21 lakhs or something. The award and the decree nowhere specifically, the award and the decree nowhere specifically contemplate for awarding 15% interest per annum on the amount awarded, including the interest component, that is the pre-award interest. So in that case, it was not the award and the decree nowhere. But in our case, both the award and the decree also. Now the decree is coming, but the award has clearly mentioned that the post-award interest will include the principal A plus the pre-reference pending interest. So this case could not have been applied, and by relying on this judgment, the trial court has changed the terms of the award, saying the post-award interest of 15% will be only on the awarded amount and not on this amount. Now, your lordship, their case was that awarding of post-award 15% interest on the total payable amount will amount to paying compound interest and interest upon interest. But that is not the case, your lordship. In this case also, as I just mentioned earlier, my lord, I may be allowed to take. My lord, in this case also, as I've mentioned, that they have relied on Oil India, Gas Commission and MC Ceylon engineers. Well, this is one of the authority in this case that has been give me that ONGC case. This is a judgment of Justice Rajendra Babu and Justice S.N. Phukan. Oil and Natural Gas Commission, 1999, 4 SCC 327. In this case, my lord, it has been clearly held that interest which has been, as your lordship is aware, that 1940 Act, there is no provision of paying interest. So, under the 1940 Act, in all the cases, the arbitrator got the jurisdiction to award interest only through judicial pronouncement. And the landmark cases, in the first case, landmark case is the GC Roy case, Secretary Irrigation Department versus GC Roy case, that is the authority constitutional bench judgment, which has held that when a person is deprived of using his money, he should be adequately compensated. You term it as interest or compensation or damage. So that is the first case, and then come the Janna's case. Only through these judicial pronouncements under 1940 Act, the arbitrator got the jurisdiction to award interest. Well, in this case, interest on interest, the headline says, powers of arbitrator regarding grant of claim made for balance payment as well as interest thereon, arbitrator awarding interest under both heads interest on the amount of interest may be termed as interest on damages or compensation for the delayed payment. Such damages or compensation would become part of the principal. Thus, Section 3 of the Interest Act disallowing interest on interest would not have any relevance in the context of the matter. The relevant paragraph in this, it comes in paragraph 4, my lord. Paragraph 4, there cannot be any doubt that the arbitrators have power to grant interest akin to Section 34 of CPC, which is the power of the court in view of Section 29 of the Arbitration Act 1940. It is clear that interest is not granted upon interest awarded, but upon the claim made. The claim made in the proceeding is under two heads. One is balance of amount claimed under invoices and letter dated 10/2/81 and the amount certified and paid by the appellant, and the second is the interest on delayed payment. That is how the claim for interest on delayed payment stood crystallized by the time the claim was filed before the arbitrators. Therefore, the power of the arbitrator to grant interest on the amount of interest, which may in other words be termed as interest on damages or compensation for delayed payment, which would also become part of the principal. So here, my lord, the pre-reference and pending interest is nothing but compensation for delayed payment, and it crystallizes with the principal amount. So any interest, post-award interest given on that cannot be termed as interest on interest, my lord. It doesn't amount to paying interest on interest. It may be termed as a compensation or delayed, but for the purpose of calculation or awarding that compensation, it is given as interest at this rate. But it is actually a compensation or damage for delayed payment, which crystallizes with the principal amount or the principal claim which has been made. And as such, the Section 3 of the Interest Act, which prohibits interest on interest, that is not attracted in these arbitration cases, my lord, here. Now, in this case also, the arbitrator has, if when your lordship has observed, has used the term simple interest. Now, your lordship, mathematically also, the calculation of simple interest and compound interest are different. My lord, compound interest will amount to, if I'm getting 12% interest, say quarterly it is going, for first 3 months on the principal amount 20,000, 12% interest, I'm getting, say, the amount becoming 20,000 is becoming another 2,000 interest, 22,000. So quarterly, after 3 months, 20 plus 22, on 22,000 again 12% interest. Then again another 2,000, 22,000 will become 24,000. Again next quarter may on 24,000 again 12%. That will be compound interest. Here it is giving simple interest. If I'm getting 20,000 total, in annually just 12% interest on 20,000. So this is not even calculated at the rate of as per compound interest, my lord. This is simple interest has been granted, and calculation is also made simple interest, and this amount under B, that is for principal and pre-reference, crystallized with the principal amount, and cannot, so the awarding of post-award interest cannot be termed as as interest on interest. And as I have said, my lord, the de Khoslas case, solely on discussing de Khoslas case, the court modified or clarified the award. Firstly, there is no scope for clarifying the award. Either court should have, if there is any such thing, court could have remanded the award back for clarification as Section 33 to the arbitrator itself. In view of any absence of any ambiguity in the award, there was no necessity was there for the courts to clarify the award. And this otherwise also does not amount to interest on interest. There are a few other case laws, your lordship. Where is that?
We continue at 2 o'clock, yes.
Okay.
Other matters also.
Please, Lordship. Lordship, if I may make a mention in item 37. Item 37, if I may make a mention. My senior is supposed to appear via VC, but due to some technical error, he cannot appear. So, can it be taken up?
He's not in the office now.
It's in the office, Your Lordship. Matter may be taken up on the next day.
37.
37, Your Lordship.
Your objection?
No, my lord.
After 1 week then.
Right, Lordship.
Other matters too. Evening. Absolutely. Not too likely to be case. How much longer will it take?
It's 10 minutes.
10 minutes.
10-15 minutes.
I think you better give your written notes. Be better.
Yes, I already have it done.
Very good.
Well, just 2 judgments only I want to rely. So just take your own lordship.
2 judgments.
2 more judgments.
Point very short.
Yes, just small point only whether it amounts to interest on interest. Now only point, as your lordship I was telling, if your lordship will once again just come to page 145 of the memo of appeal. Towards the end, my lord. Para 21.11. In view of the settled position of law, this court finds no grounds to interfere with the award of interest till date of the award. So, however, as regards grant of post-award interest under the Arbitration Act, the Honorable Apex Court D. Khosla case. Then D. Khosla case is given, and para 21.13, my lord. In view of the law laid down in D. Khosla above on grant of post-award interest under the Arbitration Act, while I do not find any ground to interfere with the rate of interest awarded by the arbitrator and the period for which it has been awarded, however, it is hereby clarified that the interest shall be calculated on the awarded amount. So what I am trying to say, my lord, to bring forth the point that only basing on this D. Khosla's case only, trial court has clarified that in the name of clarifying the award, the court has rewritten the award, which is not permissible, and modified the award. Now, your lordship, that awarding of interest on the principal sum plus the pre-reference and pendant interest does not amount to interest on interest or compound interest. In support of that, I have already relied on the judgment which I am giving. ONGC case, my lord, with Justice S.N. Phukon. In that case, I have already relied on that ONGC case, where it has been very clearly held, and this case has been discussed and relied upon in all subsequent cases, even in 1996 Act, that Haider case, which has clarified this point, that interest on paying interest on the principal plus awarded amount under principal sum does not amount to interest on interest. In Haider case also, they have relied on this ONGC case, my lord. This is the authority on that. And here the court has clearly upheld that the power of the arbitrator to grant interest on the amount of interest, which may in other words be termed as interest on damages or compensation for delayed payment, which would also become part of the principal. And if this is the correct position of law, we do not think that Section 3 of the Interest Act has any relevance in this context of the matter. So, Section 3 of the Interest Act, which bars awarding of interest on interest, that will have no relevance in this situation. Well, the second case which I would like to rely on is the Alimenta SA versus NACMF. Kindly give this copy to the court. This is of the Delhi High Court case. Do you have another copy of Alimenta? Just see. My lord, para 8, if your lordship will kindly turn to the decision finding portion, para 8, 9, then 10, operating portion. Your lordship, I may just read out this portion. Para 10, in Saraswati Construction Company versus Delhi Development Authority, the court has held, Learned Counsel for the decree holder has relied upon a judgment of Apex Court in Oil and Natural Gas Commission, the same judgment, my lord, in which their lordship considered the question of interest on interest and held that the power of the arbitrator to grant interest on the amount of interest, which may be termed as interest on damages or compensation for delayed payment, would also become part of the principal amount, and as such, Section 3 of the Interest Act as the sum adjust. In view of the aforesaid judgment, this court is of the considered view that after the passing of an award or the dismissal of the objections by the court and passing a decree in terms of the award, not only the amount of a claim upheld by the arbitrator or the court, but the pre-suit and pendential interest awarded in favor of a decree holder crystallizes into the decretal amount, and the future interest becomes payable on the entire amount comprised of the claims as well as the pre-suit and pendential interest. Therefore, from the date of the passing of the decree, the future interest is not to be calculated merely on the amount of claim upheld by the arbitrator or court, but also the amount of the interest awarded by the arbitrator or the court. Then again going to in para 12, they are again discussing the same oil and natural gas commission, that case. Para 13, I may also refer to Central Bank of India. This is another constitutional bench judgment, Your Lordship, on this point, where that interest, it crystallizes, it amalgamates with the principal amount, and that is permissible and does not amount to compound interest, my lord. This is another authority on that. And finally, my lord, in para 20, this finding is there, para 20 of this judgment, my lord. It is a settled law that the court has power to grant interest in the decree under section 34 CPC, even in cases where the statute does not make any specific provision for payment on interest and awarded sum. The court has power to award interest from the date of the award to the date of the decree, and the award of post-award interest in the decree making an award rule of the court. It does not amount to interest on interest, but rather is an interest on composite sum of principal plus interest awarded by the arbitrator. Further, even for the sake of argument, if section 29 of the Arbitration Act was to apply in the present case, the grant of interest under the said section on composite sum principal sum of principal with interest under the appeal awarded would not amount to interest on interest. Similarly, section 3(3) of the Interest Act does not bar post-award interest awarded by the court in the decree making the award rule of the court, and it does not take away the power of the court to grant interest in the decree under section 34. Hence, I hold the interest shall be payable on the consolidated amount, that is, upon the principal plus interest as on the date of the decree. This is on reference. The answer was, it was answered accordingly. So, my lord, yeah, my lord, this is that under the 1996 Act, the authority, your lordship is also aware about the Hydro Consulting Limited, where the amount of what amounts to sum under 1996 Act, section 37(1), which deals with grant of interest. In that, this in Hydro Construction, it has been clarified that the sum awarded mentioned there includes the principal plus the interest awarded for the pre-reference and pendential interest. In this case also, I will not burden your lordship by reading, but only the relevant para is para 55, where this court, my lord, Hydro Consulting UK Limited 2015 to SCC. This can even give this.
Yes.
My lord, in this case also, they have relied on the decision of ONGC case, the decisions on ONGC and GC Roy case, while coming to the conclusion that the sum awarded is will include the principal plus principal and the interest awarded for the pre-reference and pending. And then there's another judgment of interstate construction, 2025 SCC online. This is interstate construction versus national project construction before Justice Abhay Oka and Justice Ujjal Bhuya. In this case also, my lord,
no, this is 2025 SC online 708. Which judgment? This is Ferro Concrete.
no, 1127 2025 SCC online. So we have extra one, this one. We don't have the other copy now. Wait.
Yes.
Relevant para 41 It will start from 37. If this is last case law, I'm relying from para 37. If I may permit, this brings us to the second issue on which the High Court set aside the directions of the arbitral tribunal contained in para
Where are you
50,
reading from?
para 37, my lord.
This position to clarify this start like that, 37. Reading
This brings us to the second issue on which the High Court. This is the case you have given in interstate construction.
Yes.
That one?
Para?
Para 37. Give that copy. How it is not telling, I don't know.
Why given the judgment copy? This is from SC online.
Well, para 37.
Yes.
This brings us to the second issue on which the High Court set aside the directions of the arbitral tribunal contained in para 58 of the award. According to the division bench, the arbitral tribunal has committed an illegality in forging the principal amount with interest while computing the awarded amount on which future interest is to be paid. Interest awarded for the past period could not have been subjected to further levy of interest during the pending or post-award period on merger with the principal amount, as this would amount to levy of compound interest. This aspect of the matter is no longer res integra. Then para 40, my lord, a three-judge bench of this court in Hyder Consulting Limited opined that it was not possible to agree with the conclusion of SL. SL Arora has been overruled, my lord, which already of the Act does not require that interest which accrued till date of the award be included in the sum from the date of the award for calculating the post-award interest. Justice Bobde, authoring the majority opinion, was of the view that the conclusion reached in SL Arora did not seem to be in consonance with the clear language of section 31(7) of the 96 Act. Hyder Consulting declared SL Arora was wrongly decided in that it held that a sum directed to be paid by an arbitral tribunal and the reference to the award on the substantive claim did not refer to interest pending awarded on the sum directed to be paid upon award, and then in the absence of any provision of interest upon interest in the contract. So it has been clarified that
all the judgments that
sum includes
would mean the principal amount plus interest.
Plus interest, yes, my lord. And this may be the principal. This may be under the 1996 Act, but in coming to this conclusion, my lord, they also relied on ONGC case, which is under 1940 Act. They have relied on that, and the principle, same principle will also be applicable even if this case is under 1940 Act. Their submission is that this is under 96 Act, Hyder, we cannot rely on this, but the principle of the law is the same, my lord. And the latest judgment of the Supreme Court, my lord, I do not have a copy of that, in Oriental Structural Engineering Private Limited, State of Kerala, the honor.
Citation?
Yes. Citation we have given to
the basic things A, B plus C, that's all.
Yes, my
lord. That's the only thing.
Yeah, that it has held.
Yes.
Yes, even a case law, the principle under 1996.
Awarded plus interest from the cost date of the action to the date of the award.
Yes. That's your case. In this case, it was held that any decision, the principles arrived at 1940 Act will be applicable in 1996 Act. So it will be vice versa, my lord. The same principle of 1996 will also be applicable in a case under 1940 Act. It is only on that point that it was their argument that it is Hyder and these cases are under 96 Act. You cannot apply the same principle on that. So to come to a conclusion, my lord, in this case, the court exceeded its jurisdiction while passing the order by clarifying the award, which is not permissible.
Only submission is that the court by
clarifying the award,
it, modified the award.
Modified the award, rewritten the award, which is not permissible, my lord. And it is contradictory also. On the one hand, court has said the award is made rule of the court, and then also prepare decree in terms of the award. Whereas again on the other line, she's gone to say that
taken away something from
clarify, and this is not permissible. And because here and that other amount also, D. Khosla case is totally distinguishable from our case, because in D. Khosla case they have clearly held that neither in the award nor in the decree it was awarded. In that case, what arbitrator awarded was 12% for the first period on the sum awarded, 12% for the second period on the sum awarded. That is a different case. That arbitrator never awarded. He awarded on the sum awarded, and then in that case they have held that obviously the sum awarded has to be the same amount. Yes, we agree to that, but the same thing principle cannot be applied in our case, because in our case the award itself has given us, and arbitrator has consciously used the two different terminology while giving first part on the amount awarded, second part on the total payable amount. So in our case it is there, and but only thing, the one line in D. Khosla case, my learned friend may give me D. Khosla's case, that one. My learned friend may say read the last line also, because that I'll just address to that. Para 29 of the D. Khosla case, the amount awarded refers to the principal amount of compensation awarded. The award and the decree, it is clearly, they have said, the award and the decree nowhere specifically contemplates. But in our case, the award contemplates for awarding 15% interest per annum on the amount awarded, including interest component, that is pre-award interest. This could not have been done even otherwise, as there is no provision to that effect under the relevant statute or the contract. This observation is totally not tenable, my lord. This is only an observation. This could not have been done, as there is no such provision in the statute.
Where are you reading from?
D. Khosla's, the last paragraph, my lord, para 29. The last para 20, second last paragraph 29, my lord.
In a plain reading.
The amount awarded, next paragraph, my lord. The amount awarded refers to.
Very strange.
Give that one. I don't know how it is.
I don't know what, you have to read some uniformity, otherwise.
So I've got two copies of the same.
Huh? You give one copy, no, give another copy. It's
Same. The second last paragraph, para 29, my lord.
It's para 27.
How come it's different? '28 is not 27 here.
Oh.
29 does not exist.
Oh. My lord, just now which I gave, your lordship can refer to that one. I'm having the similar.
The thing is, let's see. See, 28 in this, in your thing ends at this one, two distinct amounts.
Two distinct amount, yes. Then 29 starts, the amount awarded.
Very strange. Oh, this is where they downloaded from. This is from the Supreme Court website. There's a neutral citation.
That is.
The para 27, my lord.
This is.
Kindly see para 27.
Para 27, yes. Para 27 is
Last
broken
two
into two.
Last two sentences.
See, it's been broken into two in this SEC online. Is it permissible?
I don't know.
This is authenticated one, because this is a Supreme Court.
Yes, sir.
Uploaded by the Supreme Court website only. But this SEC online, see what they've done is, now here para 27 starts a plain reading. You just see this one.
A plain reading, that is
neutral citation, okay.
Okay.
And then it ends with distinct amounts, correct?
Distinct amount, yes.
But in the original one, there's no split. It is
continuation.
The paragraph continues.
Okay.
So he asking to look for paragraph, it's not there. The amount awarded is not there.
I'm sorry for the inconvenience, my lord.
Better be sorry, otherwise it's creating a lot of confusion.
Inconvenience for the courts.
I'll refer to that, my lord, but that is my main plan.
A plain reading, the award and the decree nowhere specifically contemplate the awarding 15% interest per annum the amount awarded, including interest component. That's pre-award interest. This could not have been done even otherwise, as there is no provision that affect the relevant statutes.
Yes, that much. Here, at this point, I would like to submit, my lord, as there is no provision in the statute. My lord, so far as in 9, the question of provision in the statute does not arise, because it is known fact that this is under 1940 Act, there is no provision of interest. Under 1940 Act, the arbitrator is getting the jurisdiction only through judicial pronouncement. So the question of making this observation that there is no such provision in the statute, it does not, it was not required.
Otios.
Yes.
I mean, it's otios.
Yes. So this is what I want to say. I mean, that was not, but and this is only an observation. That was not the decision. So that will not work. But what is there decided in that, in their deciding portion, where they have said the award or the decree nowhere mentions. But in our case, the decree, the award clearly gives two different amount and not. So this is how D. Khosla is distinguishable, and the court below only relying on D. Khosla's these observations that amount awarded has to be same for both the period. So has wrongly exercised the jurisdiction and clarified the award, and this has caused serious prejudice to the party, to the petitioner, my lord. And here, because it is otherwise also, this does not amount to, as I have said, my lord, this does not amount to interest on interest, where GC Roy case has clearly held, while GC Roy case is the authority, is the constitutional bench judgment, first judgment on giving the power and authority to the arbitrator to grant interest. And in that case, for granting that pre-reference interest, the court has clearly held that when a person is deprived of using its money, legitimate dues, it has to be compensated, name it by any way, interest, compensation or damages. So pre-reference and pending delight, which is given, that is not interest, to say interest as well, but it is a compensation or damages. But how to give it? It is given by way of an interest at this rate, and this amalgamates with the principal amount, making it as a composite awarded amount. So any further interest, future interest on that composite amount does not amount to compound interest or interest on interest. This is my case, my lord.
Yes.
So I can release, I'll give just few dates, my lord, in this note.
My lord, I have prepared one just gist of my submissions. We will submit.
Yeah.
Few relevant dates here, my lord. Now, my lord, to begin with, the present case is under Arbitration Act 1940, my lord. Now there are two distinct era, my lord, if I can say so. Under the old Act, my lord, 1940 Act, there are three specific periods. And that's what I've tried to mention here in this, my lord. From the date of cause of action, my lord, till the date of award. Date of award to date of decree by the under section 17 of the old Arbitration Act, my lord. And then from the date of decree till the date of payment. So these are three distinct periods. Under the new act, the decree concept has been done away with, my lord.
No, it doesn't make order of the court, not necessarily.
So now there are only two periods.
Yes.
Cause of action to date of award and date of award to date of payment. So the intermediary period is not there now, my lord.
From the date of award to decree.
My lord.
To make rule of the court. Yes. Yes.
Now, my lord, under the old Arbitration Act, there is no provision for grant of interest anywhere, my lord.
Yes.
Whereas in 1996 Act, section 31 specifically deals with payment of interest, my lord.
Yes.
By judicial pronouncement, my lord, in GC Roy's case, that has been referred as Constitution Bench decision.
Yeah.
Supreme Court held that pendent light interest can be granted under section 34 of the CPC, because CPC is applicable to arbitration proceedings and it is a court.
Yes.
GC Roy only says to that extent, my lord. I am not disputing that provision, my lord.
Yes.
So learned arbitrator has awarded 12% interest from the date of cause of action till the date of award. There is no problem, my lord.
Yes.
The real dispute is with regard to the intermediary period, my lord.
Date of award, date of decree.
Date of decree.
Yes.
Here what happened, my lord, decree was passed in 2017. That has been, was actually passed in 2017, my lord. 2017.
17.
Yes, my lord. Then we came to High Court, and High Court set aside, my lord, remanding the matter back, and the revised decree was passed in 2025, my lord, last year.
Okay.
So that's why
award was as far back as in award was.
It was pending for 14-15 years in the trial court, my lord. In 2017, there was.
After the award was passed, then applications filed by them for making a rule of the court.
And we also filed challenging under section 3033, my lord.
Years?
That took 14 years, my lord.
No, in 2018 it was passed.
Yes.
No, the award.
Award is 2003.
No, that 2018 that was set aside. I mean, the award was made rule of the court.
Whatever this,
I'll clarify
what we are asking is that interim period, like which is from the date of the award to
Yes.
the date of decree. When is the award passed? 2003.
2013.
3 or 13?
2003?
5/9/2003.
Or 2003.
2003. So after award now 2003, the final decree was passed 25.
2018 first, my lord.
Okay, 18.
But it was because it was ex parte.
Notwithstanding any other.
Yes, as it stands now, it's 20.
But notwithstanding anything else, that means, factually,
Actually, it's 25. my lord.
5/9/23, that means 25.
Okay.
That's 22 years
22
after the award.
Yes, my lord.
Okay, yes, after that.
So, my lord, 3 periods I mentioned, my lord. First period, GC Roy said that section 34, CPC, my lord. Now, I'll just take your lordship to section 34 of CPC, my lord.
Yes.
It says, my lord, where and insofar as decrees for payment of money, the court may, in the decree, order interest at such rate as the court deems reasonable to be paid on the principal sum adjudged from the date of suit to the date of decree. So, pendent light interest in a civil suit can be granted, and that is what
Yes.
GC Roy said, that this provision will also apply to. So, there is no dispute, my lord. Arbitrator has granted 12% interest. That is fine. Well, now about 20 lakh rupees was the principal sum awarded by the arbitrator, my lord.
Yes.
Now, just to divert, my lord, we had to deposit 2.5 crore rupees against an original award of 20 lakh rupees by calculating interest in the manner they want to calculate, my lord. And that has been deposited. 50% money has been secured. 50% has been released to them, my lord. Now,
20 lakh award.
On the 20 lakh award, my lord. Now, the third period, if you come, lordship, and this is very relevant, my lord. Date of decree till date of payment. Now, my lord, I'll just place the statute, my lord, Arbitration Act.
Yes, hold
that. I have a copy, my lord.
No, we have a copy. Okay.
Hold that.
Yes.
Kindly see section 29.
Yes.
It says, my lord, where and insofar as an award is for payment of money, the court may, in the decree, order interest from the date of decree, my lord, at such rate as the court deems reasonable to be paid on the principal sum adjudged. Section 34 also talks about principal sum adjudged, my lord.
Also section 29.
So first period in the table, my lord, first period also has to be on principal sum adjudged. There is no dispute because there is no arrear interest in that, my lord. So that 19 lakh is the principal sum adjudged. There is no problem in that, my lord. Third period, Act itself says on the principal sum adjudged. Now, can there be a situation, my lord, that for intermediary period,
from award to decree,
we will be A plus B?
Yes. 22 years.
Those 22 years, my lord.
Yes.
So I think I'm clear, my lord. First period, statute says on principal sum adjudged, my lord. Third period also statute says on the principal sum adjudged. Can the intermediary period be a different parameters, my lord? And for that period, can interest be calculated on? And that too, when there is no provision either under the CPC. CPC section 34 only talks about power to grant interest for the period from the date of filing of the suit till the passing of the decree, my lord. Section 29 of Arbitration Act from the date of decree to the date of final payment, my lord.
Yes.
Now there is a clear vacuum for period 2, my lord. There is no statutory provision, and more interestingly, my lord, there is no provision in the contract. They have not been able to cite any provision before any court that there is any provision in the contract for payment of interest, my lord. This is relevant because in every decision cited by them, or whatever I will be citing, my lord, court says unless provided in the contract or the statute, my lord. So that is where now the question comes, my lord. What will be the rate of interest, or what will be the amount on which interest has to be calculated on for the second period, my lord?
Yes.
And for that purpose, I relied on SD Costa's decision before the trial court, my lord. This is a 2024 August decision, my lord. And I'll read this judgment in entirety, my lord. Because only selective few paragraphs were read.
Yes. You read which part? You read the SC online one or the neutral citation?
Neutral citation.
SC. Only one caveat is this court can sit up to 320 max.
No, my lord, I have also 3 o'clock of matter fixed, my lord, division bench. Yesterday's matter is again fixed at 3 o'clock.
Yes, because some we have something fixed at 3:30. Yes.
But the bench is there, my lord.
No, like the 3:30 is from the CJ only.
But the lordship have to release me 5 minutes before 3, my lord. I think that matter will not take more than half an hour. We argued yesterday.
It's only sitting now. Single bench.
Division bench. After this division bench.
As you continue another day.
I can do that also.
Yes. When?
Next year, next week, my lord. Because otherwise, again, this is long gap.
Yes, of course. But only thing you're never available. That's the only thing.
No, I appear when a matter is fixed, my lord. I appear.
No, you're very busy.
No.
So,
can we have it on Monday next? 15th?
just coming Monday?
Yes.
Yes, why not? Just for further hearing on.
15th.
Yes.
Obliged.
Very interesting point.
Because another aspect is, my lord, even the rate of interest is under challenge in my appeal, my lord.
At 12%.
Yes, 12%, 15%, 18%. That is another aspect, my lord. But the court could have granted 12%, 15%, and post decree 17%. My lord. In today's time, my lord, no bank gives more than 6%.
Yes. What's commercial rate? 18%.
17.5%, my lord.
Commercial rate now?
Commercial rate.
I'll pay some reasons.
17.5%.
Which bank is giving 17%?
We have given that certificate before the court also. 32. Obliged, your lordship.
Which bank is where you take money from the bank, they'll charge you?
It's still 13%.
Not a question that the bank will give you. Yes.
33 also, no? 32. 32? 32 is the same, no?
No.
Yes.
The counter. Another one.
31.
Oh,
31.
Sorry. Obliged.
Yes.
May it please, your lordships. On 3/3/2025, your lordships were pleased to grant us the interim prayer of release of the frozen amount of 20 lakhs, my lord, subject to submission of a bond before the bank. Accordingly, my lord, we have done that, and the amount has been released, my lord. Now, my lord, the question is, my lord, the finality of that order, my lord, the law behind it. If I may take your lordships to the FIR, my lord, at page 35. At 33, my lord, is the
Page 35.
Yes, my lord. 33 is the relevant part, my lord. Type copy.
In Hindi?
It was in Hindi, my lord. It was translated.
Who's the complainant? Dr. Turi is the complainant. Yes.
Without troubling your lordships with the entire FIR, if I may just take your lordships to the second last sentence of page 33, my lord.
Yes.
This gives us the gist of the allegation, my lord. If I may read.
Yes.
When I called again the next day, Rinkuji, which is an employee of the petitioner company, told me that Mr. Santosh, that is my lord, respondent number 3, has brought 2 cars from their showrooms from my payment of rupees 20 lakhs. And after that, when I protested and said when someone else's bill has been made, how can it be adjusted? And that this was nothing but complete fraud done by the company. Mr. Rinkuji informed me that Roshan had spoken to Santosh and that he had informed that he will make the payment for my car in 1 to 2 days and then they will deliver my car. Thereafter, I tried to contact the Highland Toyota's higher authority / owner / vice president several times, but Rinkuji and Roshanji always asked me to wait for some time. One day, Roshan called me up and asked me not to complain to the higher authorities as he might lose his job and that this was not his mistake alone but their accounts and head staff is also involved. This made me realize that the entire sales staff along with the account staff head persons have all along with Santosh have frauded me of my 20 lakh rupees. This is the allegation in gist, my lord. Santosh is respondent number 3, my lord. And at the very beginning of the FIR, again at 33, my lord, who is this as respondent number 3, my lord? My lord will again see from third sentence, my lord. The undersigned needed a Toyota Fortuner for his domestic needs, and during that time, I happened to meet Santosh Singh and Raj Purohit and Sunil Singh Raj Purohit.
From?
From the third sentence at page 33, my lord, FIR.
To respect of in charge, they said, the other signed to the yes.
This part tells us that it is respondent number 3, my lord, who solicited it to respondent number 2. And there was no solicitation by petitioner company at a distant place, my lord, in Rajasthan. So, my lord, meaning thereby that when there is no solicitation, my lord, there cannot be a criminal intent, my lord. Thereafter, my lords, sometime in July, my lord, of 2024, just a simple SMS was received by the petitioner company stating that this amount has been released, has been frozen, my lord, not released, frozen. Thereafter, my lord, several correspondences with the bank. Bank had just, my lord, forwarded the FIR, my lord, that I just read, only saying that because of this, we received an intimation from SBI Ramganj Mandi branch that this amount needs to be frozen. Interesting part, my lord, is that the amount was not even credited from SBI Ramganj Mandi branch. It was credited from, my lord, UCO Bank. And that was the information that was just verbally told to the petitioner company. Thereafter, my lord, we had filed this instant writ petition, my lord, and then by wide order dated 3/3/2025, lordships was pleased to grant that interim relief, where, my lord, the amount was released after submission of the bond before the bank. After filing of the petition, my lord, we also came across the charge sheet. If I may take your lordship to our affidavit in reply, my lord.
What stage is the case now?
The case, my lord, the charges are yet to be framed, and only, my lord, respondent number 3 has been charge sheeted. Not even the individual employees, my lord, named in the FIR have been charge sheeted, and the account doesn't even, my lord, belong to the employees. It belongs to the company, my lord, and no allegation whatsoever, my lord, in the FIR or subsequently in the charge sheet. that is another thing lordship will have to consider, that the company has a separate juridical identity, man, and no allegation has been made against the company that required freezing of that amount. Moreover, my lord, before I take your lordships to the charge sheet, as a matter of fact, I would like to take your lordship to Annexure A
of your writ petition.
Of the writ petition, my lord. Page 24, my lord. Respondent number 3 utilized part of that amount for taking this car for this client. This we had already submitted before the investigating authority as well, my lord. Similarly, respondent number 2, my lord. And similarly, my lord, Annexure D is another car wherein that 20 lakhs was utilized. So my lord will see that both of these cars are up to a value of around, my lord, 28 lakhs, and the respondent number 2, my lord, kept on crediting amounts from different accounts, different account holders, my lord, and some of the cars were also delivered to his multiple clients with the petitioner's company, my lord. And this is, my lord, is a matter of practice in the car sales business, my lord. Oftentimes, my lord, customers, they would, my lord, be making payment for vehicles from different sources. It could come from various sources, man. And here in this case, this concerned amount, rupees 20 lakhs, this account name is called Amish Doodh and Kirana, my lord. It doesn't even have the full name of respondent number 3, my lord. Thereafter, lordship may come to our affidavit in reply, wherein we brought on record the charge sheet, because, my lord, it was obtained after we had filed the writ petition. Page 9 is where the charge sheet starts, my lord. And relevant part at 9, my lord, will see towards the bottom at serial 11, my lord. Particulars of, yes, my lord. Particulars of accused persons charge sheeted. Santosh Singh Rajpurohit. Thereafter, my lord, in the next page, page 10, at the very bottom, my lord, serial number 12, page 10, my lord, very bottom, particulars of accused persons not charge sheeted. Number 1, my lord, Sunil Rajpurohit, one of the brothers of respondent number 2, who was mentioned in the FIR. Then again at the bottom, my lord, Roshan, that is the employee of the petitioner company, my lord. Then, my lord, again at next page, page 12, my lord, serial number 3, Rinku, another employee of the petitioner company, not charge sheeted. So, my lord, they are not charge sheeted. Now, my lord, I would like to take your lordship to an important part of the charge sheet at page 27.
Yes.
Page 27, my lord. At the bottom part of the paragraph, my lord, at the very right hand side, lordship will find this sentence, by conspiring.
Last paragraph in page 27.
The first paragraph, my lord, towards the end, towards at the right, my lord, the last 5th or 6th sentence, my lord, by conspiring.
Yes.
By conspiring with Santosh Singh Rajpurohit, this is, my lord, the charge sheet, the police's observation. By conspiring with Santosh Singh Rajpurohit, the complainant's car was booked. The amount was deposited in the company's account and the amount was shared and the principal amount was reduced. Santosh Singh Rajpurohit got rupees 20 lakhs adjusted in other cars and the booked cars were delivered. And even though in this translated version, my lord, I have written by conspiring with the complainant, my lord, it should have been conspiring against the complainant, because in Hindi the word that is written is saath. So saath could mean against or with. So my lord, this my lord may pardon this mistake. Otherwise, it's supposed to be conspiring against the complainant. So this part makes it clear, my lord, that adequate value of goods have been already taken away from the petitioner company, and that goods are supposed to be, my lord, the proceeds of the crime, my lord, and not the amount, my lord, that was lying with the companies. Thereafter, my lord, what is the law, my lord, behind it? My lord will appreciate that this whole issue arose at a unique time, because FIR was registered on 24/7/2024, my lord, but BNSS had come into force on 1/7/2024. So my lord will see that the substantive provisions are from IPC, because those incidents happened before BNS came into force, but procedural part is now governed by BNSS, my lord, because after FIR was registered after, my lord, BNSS came into force. Now, I would just like to trouble your lordships with the criminal provisions, even though, my lord, we are in a civil proceeding, but just to show your lordship what the provisions are. If lordship goes to CRPC 102, my lord,
yes, why seize property?
Power to seize property, my lord. Now this verbatim provision, my lord, has been incorporated in BNSS under, my lord, section 106, my lord. 106 is the corresponding provision under BNSS. But what, my lord, BNSS has also in addition incorporated, that is not in CRP, is 107. If my lord may come to 107 of BNSS.
Yes.
107 says, my lord, where a police officer making an investigation has reason to believe that any property is derived or obtained directly or indirectly as a result of a criminal activity or from commission of any offence, he may, with the approval of superintendent of police or commissioner of police, make an application to the court or the magistrate exercising jurisdiction to take cognizance of the offence or commit for trial or try the case for the attachment of such property. Rest of the provisions, my lord, lay down the procedure. Now, my lord will appreciate that so far from respondent number 1, my lord, we have not received any form of contention as to under what provision this was initiated, and no such documents, my lord, have been placed, and which provision have they relied on while initiating this.
What do you want here in petition?
Now, my lord, we
like a criminal revision, yes.
We just want, my lord, finality of the interim order, my lord, because there is no nexus, there is no criminality by the petitioner company, and there are three judgments are there, my lord, because this is not a very well developed law yet, but 3 judgments have addressed this. Yeah. I have framed a written argument for your lordship's.
May please your lordship, if I may, the limited issue in this writ petition, lordship, because this is not a criminal case before your lordships, the limited issue in this case, lordship, is primarily who is the bona fide owner of the funds. Is it the complainant or is it the petitioner? Because the complainant was defrauded by the fraudster and induced into transferring his funds into the petitioner's bank account. Now, against that, he did not receive any goods. So the complainant was defrauded, and the petitioner, on the other hand, Their argument is they were bona fide when they took the funds and they delivered a car to the fraudster. So what we have here, Lordship, is we have a fraudster in between who has defrauded the complainant, taken his money, got the money. Lordship?
The Santosh, whatever.
Yes,
Santosh is the accused, is the main accused. The officers of the petitioner have not yet been charge sheeted, but that's not outside the realm of possibility. A supplementary charge sheet can be filed subsequently. Investigation is ongoing. Those are my instructions. So the limited point before your Lordship, before the writ court, is who is the bona fide owner of these funds? As far as squashing, as far as all other matters that my learned friend has raised, these are criminal matters. They're outside the purview of a writ petition. So the limited point before your Lordship is who is the bona fide owner of these funds in these circumstances? Is it the complainant, or is it the petitioner who received the funds and delivered a car to the fraudster? We have a fraudster in between.
Where's the fraudster now?
The fraudster was granted bail, Lordship.
Granted bail, right?
Sorry? No, he was granted bail. He was again arrested. I'm informed by my colleague that he was arrested again, post bail.
My lord may produce my written arguments only for your lordship's assistance. I have also provided relevant citations.
Not really satisfied as yet. Yes.
And my lord,
how will we discern? I mean, how will we determine this? Where the funds should be located?
No.
Now you've given a bond, right? Your money's come out. So yes, Mr. Turi.
My learned friend is.
You're for the complainant, right?
Yes, Lordship.
So you had been induced by this respondent number 2.
Respondent number 2 as well as the employees of the petitioner, Lordship, because they were in connivance. Everything was done at their knowledge. I was sitting there in Rajasthan on belief that on payment I will be getting the delivery of the car. Although induced by
Why do you buy from Rajasthan? Why do you buy all in Rajasthan? Why do you buy car from Meghalaya?
Lordship, because there were certain offers going on which were provided and induced by respondent number 2 to the fact to be admitted, and but the adjustments of funds in other accounts, which is normally not the practice performed by any of the car dealers all over India. I don't know how my learned friend has submitted that it is a usual practice. It is not, because it's a high value amount car. Even for income tax compliance and everything, payment just cannot be adjusted from here and there. So that is not the practice at all. Now, so far this present petition is concerned, Lordship, I will not argue on the point of your Lordship's power to issue the interim order to the petitioner, because under 226 clause 2 of the Constitution, Lordship has power where even the cause of action partly or wholly arrives in the jurisdiction of the Honorable Court. Whether it arrives or not, since your Lordship has already passed order, I am not on that. But the thing is, Lordship, the FIR is pending, charge sheet is done, case is pending before the judicial magistrate.
Let law take its course.
Lordship?
Let law take its course.
Law take its course. But so far the FIR is filed, charge sheet is filed, case is pending before the judicial magistrate. Notices has been issued to the petitioner, to the employees of the petitioner to appear before the judicial magistrate as well as the police, but they are avoiding till date, and they are taking the shield of the present pending case by not appearing before the authorities for proper investigation of the matter, Lordship. Second thing, Lordship, their prayer in the petition was they wanted release of the fund which was blocked on the direction of the police authorities under section 106 of BNSS, and it is not a fact that it was not intimated to the magistrate. It was intimated. Subsequently, magistrate also issued notice, but they failed to appear before the magistrate as well. So the thing is, now their prayer in the writ petition was they wanted release of the amount upon furnishing indemnity bond before the police authorities. But I don't know how, maybe because of wrong submissions, or the indemnity was submitted before the State Bank of India, Ribhoi district. Now, Ribhoi district State Bank was not the authority who had seized the amount. It was upon the instructions of the police authorities under 106 BNSS. So my prayer is that interim order, since already court has granted, that may be altered by directing them to give indemnity bond before the police authorities, as well as appear and participate before the magistrate and police authorities.
Where is that order?
Lordship, that order is interim order, Lordship.
Not interim order, the order granting allowing them to furnish the bond. Where is that?
Lordship, order dated 3/3/2025 in this present writ petition, Lordship. Paragraph 7, Lordship. And a Lordship,
So there's no direction for putting the bond before anybody. It's just a furnishing and indemnity bond.
Yes. Before the Lordship, respondent number 4, that is State Bank of India. And your Lordship may side by side turn to page 22 of the writ petition, 21, which of interim prayer they have referred.
Yeah.
Page 21 onwards, the interim prayer.
Proposal.
Suspend the impugned action of respondent number 1 in directing respondent number 4 to lien mark on the amount of rupees so and so from the current account of the petitioner subject to execution of bond before the investigation officer.
Where is that?
Lordship, page 21 of the writ petition, the prayer portion. 21 down below is the interim prayer.
Yes, pending before the rule, it was 50 suspend action directing on the current. Yes.
Subject to execution of bond before the investigation officer, Lordship. That is respondent number 1.
Why the order pointed out to the court
Yes,
when the order was passed?
And if I may be permitted to present the subsequent status, Lordship.
Who's Mr. Bhuya?
My learned senior, he was there. We had, it is true, my lord, that this prayer is regarding before investigating officer, but it is, my lord, it is well within Lordship's power under 226, my lord, to amend the prayer as your Lordship pleases, my lord.
If I may submit, Lordship, that will go against section 106 BNSS subsection 2, Lordship.
But BNS will not
Because
apply in
once
a writ
done,
petitions,
that
my lord. That
police authorities have authority to take in bond and release the liens or the seizures, Lordship. If I may just place the current status of this matter, Lordship, I may be excused that I am not filing by way of affidavit, Lordship. Lordship will find the copy of the notices which have been issued to the managing director of the petitioner as well as the manager under section 35(3) of BNSS by the police authorities to appear before them in the investigation. Page 1, 2 are the English versions, 3 and 4 are the Hindi versions, Lordship. Then page 5, Lordship, that is reply submitted by taking seal of the present pending proceeding, Lordship. They have said that they are unable to appear before the
no, my lord. We said we will cooperate. We just sought time, my lord. That is completely wrong.
Till date, they have
my
never
lord,
tried
see
to
that
appear.
reply. That is drafted by me, my lord. We said we will cooperate and appear. We just sought some time for obtaining records from the trial court, my lord.
And the charge sheet which my learned friend has referred, Lordship, although the respondent number 2 has been charge sheeted, so far other concerns are present, that is still pending. That is the observation in the charge sheet, because they are still to appear and participate in investigation, that is pending. So subsequent charge sheet can always be filed by the police officers once it is found that they are in connivance with you.
Yes, Mr. Bhotapur.
Yes, my lord. I would like to rely on Supreme Court judgment to how to deal with this issue, my lord. How an amount that has already been released. If Lordship comes to para 27 of the judgment at page 17, my lord.
Page?
Page 17. Here, my lord, the issue was whether delayed reporting to a magistrate about freezing, does it vitiate the freezing? Supreme Court has said, my lord, it does not automatically vitiate the freezing, but at the end, this is the direction of the Supreme Court, my lord, at para 27. The reasoning adopted by the High Court cannot be sustained in light of aforesaid discussion. This takes us to the consequential question, namely, whether at this distance of time we ought to direct freezing of the bank accounts afresh. The answer has to be negative, since undisputedly, by virtue of the impugned order, the bank accounts of the respondents has been defreezed and resultantly.
The same order will apply to you.
Yes,
at one before the authority.
At the end, my lord, just this last sentence. Why I am saying the ends of justice would be met and interest of the prosecution would be served if the respondents are called upon forthwith to execute a bond undertaking to deposit the amount before the jurisdictional court in the event the court were to return a finding of guilt against the accused person. So they are accused persons. Here, my lord, the bank account belongs to the company, which is, my lord, not even an accused. So how can we submit a bond of something which we are not even accused of, my lord? That is one.
Why not? Maybe complicity will come out later on. How would you say?
Ownership is still in question of the funds.
And we have already provided adequate value of goods.
So how do you have access to the funds? You're an employee.
No, my lord. The managed.
Who are the others? They're not before this court. They're not mid party. Your employees not mid party here.
They're not.
Employees are not party here.
And if I may, Lordship, I placed a status report of the police station for your Lordships, which takes us through the freezing of the account. This is the status report dated 3/4/2026. I placed it before your Lordships on the last occasion. There's an index, and then item, the serial number is 1 to 5 documents.
Yes.
Serial number 1 is the status report dated 3/4/2026. At page, translated version is at page 2, just before 2, Lordship. So if your Lordship sees, if my Lordship may read this.
Yes.
Further, Lordship, if I may.
It simplified the matter. You furnish the bond.
If
yes. Anything else?
We can furnish a bond.
Further, Lordship, if I may, on the obverse of page 2 is the order of the CJM's court, which granted the petitioner an opportunity to make their representations on the issue of the freezing. And they did not participate.
My lord, that is not addressed properly, my lord. We'll see.
Instead of
it doesn't
going
even
to the
have
CJM's
any
court,
name.
as per the procedure mandated by criminal law, they have appeared before your Lordship in a writ petition.
This one.
Yes.
This notice, my lord, will see 29.
Will not go there.
Yes.
See that the matter sees there. What we'll do is you furnish a bond before the IO there.
We can furnish a bond.
Take part in the
We
proceedings.
will take part, my lord. But my lord, it may not be again taken back to the freezing stage, my lord. Only that thing. Yes.
Once it's
Those matters
unfrozen,
have to be left open.
Then, my lord, we are.
You take down then. Number 1. Yes. The incident petition. This is by company.
By company.
It's a company. Use with the prayer for. Setting aside the impugn action. Setting aside the action of the respondent number 1. in directing the respondent number 4 bank, right?
Bank.
Yes. Bracket SBI to Lian Mark LIAN MARK an amount of rupees 20,25,000 from the current bank account of the petitioner company and for other reliefs. The background facts surrounding the case are that when's the FIR file?
FIRs.
Where is it?
Page 33.
Page 33.
33.
And FIR dated.
Dated 24/7/2024.
24/7/2024 was lodged by the respondent number 3 before the what police station is this?
Respondent number 1.
Before the respondent number 1
Police
station. That is Ramganj Mandi, RAMGNJ, Ramganj Mandi Police Station, District Kota, Rajasthan, complaining about being defrauded with regard to the purchase of cars from the writ petitioner company. Stop. Thereafter, what happened after the investigation on the lodging FIR? What happened after that?
The investigation was going on, and
thereafter, on the case being registered, the investigation commenced. And where's the
charge sheet? Charge sheet is in affidavit in reply.
And
page 9.
And a charge sheet has since been filed.
That is on 11/11/24.
On 11/11/24.
24.
Charge been filed on 11/11/24. So what do you do not charge sheeted?
Not charge sheet. The employees of the companies.
But the named persons in FIR, that is the employees, have not been charge sheeted as per the has not been charge sheeted.
Pending investigation, Lordship.
Yes, charge sheeted, and the matter substantially is still pending investigation. Stop. In connection with the investigation, the IO, whether order, an order for freezing of the account.
There's no order, my lord.
The report states that funds were frozen on 3/8/2024.
Where is that?
This is in the report, Lordship. We don't have the order.
There's no order, my lord.
But this is in the report of the police station.
That's a status report only.
Status report. It's the data is mentioned.
One second. Yes, my. Yes. Comma. Very good. It appears. Which page is that?
This is the second page, Lordship.
It appears.
Obverse of the translated copy.
That During investigation, the investigating officer got the amount of rupees 20 lakhs deposited by the complainant on the account of the petitioner company, frozen on 03/08/2024 through the local SBI branch, and the complainant thereafter had sought release of the frozen amount. From the
Additional Chief Judicial Magistrate from
the Court of
the Additional Chief Judicial Magistrate, District Court.
From the Court of the Additional Chief Judicial Magistrate, Ramganj Mandi, Kota. Stop. It appears thereafter that while these proceedings were on, the instant petition has been filed. And this court, by order dated 3/3/25, had directed that the amount be unfrozen in favor of the writ petitioner, but that a bond be furnished before the bank. That's point number 4. So, it is submitted by Mr. Aibathokur, that counsel for the petitioner. What is submission?
Submission is that, my lord, the company is not an accused.
As submitted that the writ petitioner company is not an accused in the criminal case, but the amount has been kept in lien due to the actions of what do you say, that you have employees only?
And my lord, adequate amount of goods have already been supplied, my lord.
In spite of supply of goods against the said amount deposited. He therefore prays that the writ petitioner company, not being culpable in any manner, the interim order dated 3/3/25 be made final and the amount no longer remain in dispute. Correct?
Yes.
Stop. Then Mr. ESD, appearing for the respondent number 1, has however submitted that, notwithstanding the fact that the amount had been frozen from the account of the writ petitioner, who do not names accused, collateral proceedings, the proceedings which are on with regard to investigation, involves the employees engaged by the writ petitioner company. The Santosh is an employee.
Not an employee.
He's the independent fraudster.
An independent accused who has facilitated the entire, what we can't call a scam, the entire transaction. Yes, transaction, which has prima facie resulted in a loss to the complainant. Stop. He further submits that the writ petitioner company, taking shelter of the proceedings pending for this court in the present petition, are not cooperating with investigation. And as such, this has created a deadlock in the investigative process by the respondent number 1. Then Mr. Dr. Tori, what is your submission?
The interim order may be altered by submitting bond before the police authorities.
Dr. A. Tori, appearing for the complainant, respondent number 3, while endorsing the submissions made by the learned by Mr. ESD for the respondent one has drawn attention of this court to the interim prayer made in the writ petition and submits that the specific prayer is for furnishing a bond before investigating authorities, but however, the bond has been furnished before the respondent before bank. He further prays also that the proceeding be closed to enable the investigation of the criminal case to proceed more expeditiously. That's it. Yes. Like on hearing the counsel of parties and on the observations made above as to the genesis of the matter and the fact it's travelled to this court by way of the writ petition. It is petition. It is this petition. Without further lingering with the matter, it is therefore directed that since the and as the amount has since been unfrozen, the further directions issued to further orders issued to direct the writ petitioner to furnish a bond before the investigating authorities at respondent number 1 jurisdictional before the CGM or before the
better, my lord, before this.
We'll mold it that way, Mr. Dr. Tony.
Lordship, before
CGM would be
CGM
better.
before CGM.
Yeah, before CGM will be better.
Since it's already before the CGM
Yes.
now.
Tom? Jurisdictional magistrate to where the case has been committed. Yes, that is
Additional Chief Judicial Magistrate, Ramganj Mandi, Kota.
Additional Chief Judicial Magistrate, Ramganj Mandi,
District Kota.
Kota District, Rajasthan, within a period of
4 weeks may be given, my
in a
lord.
period of 4 weeks from the date of order. Stop. It is further made clear that the other parties here,
No, my lord.
the petitioner, if necessary, shall cooperate with the investigation as in progress. Stop. As ordered above, writ petition stands.
My lord,
Yes.
Question of ownership of the funds should be left open.
That's obviously open,
That
Lordship.
was to open sub investigation. See, the bond has been furnished. The thing is that if the ownership, if the after investigation and trial find that the money, then the bond will be encashed. Whatever.
My lord, may I pray for one liberty for the petitioner company to, my lord, approach this court or the office bearers of the petitioner company against any coercive action, my lord. Only this liberty.
See,
Lordship, the liberty is before the court in Rajasthan.
Any
Lordship.
cause of action, any fresh cause of action cannot bar you from approaching the courts.
Against the proceedings, Lordship, they have course of action before the High Court of Rajasthan, Lordship. For anything against the course of action, they have the remedy before the
Jurisdictional High Court. Yes.
Lordship.
Jurisdictional High Court.
34.
Much obliged.
Wait for me.
God bless.
Yes.
Lordship, Mr. Usung will appear through VC, Lordship.
Yes.
Your Lordship, this is that OMR mistake matter, Your Lordship, wherein the petitioner had mentioned in his application form that he is applying.
I'm sorry, but the court has to rise. We have to take it another day.
Your Lordship, on the
Can you bring
last,
some authorities to show that it'll be acceptable? Because whatever I think
Yes,
as it stands, that mistake
Yes,
is
in fact,
that mistake is fatal.
Your Lordship, I will try my best to
You try your best,
distinguish
otherwise
from-
as just note the court observations, that mistake made by the person and in not shading the sports person is fatal. Yes.
Your Lordship, may I please be allowed to convince Your Lordship?
No, we are rising. Please produce authorities. Yes.
Yes, Your
One
Lordship, I will bring
yes.
authorities.
Yes. Yes. 1 week.
Grateful, Your Lordship.
Yes.
Your Lordship, in this matter, on the last date, I was given a final opportunity of 2 weeks to file my rejoinder, Your Lordship, but due to unavailability of the
hearing column.
yes, Your
It's already
I'm ready with my rejoinder.
Fix here.
Your Honor, I'm ready with my rejoinder. Your Honor, I just leave.
Yes. Finally, rejoinder, not accept rejoinder anymore.
Your Lordship, it's ready. It will be highly prejudice the.
You file it today then?
Yes, Your Lordship.
Let them file it today then. Though this matter is fixed for hearing today,
yes, it's ready.
But a final apology allowed on 14/5/2026. Mr. SDEP, Mr. SDEP submitted due to
unavailability of the petitioner, Your Honor.
Due to unavoidable circumstances, the same cannot be filed. He prays that be allowed to file rejoinder today itself. I pray is allowed this.
Highly obliged.
Just after 1 week or 2 weeks.
Oblige, Your Lordship.
2 weeks.